Hey, what's up, guys? Welcome to the Mickey Mouse Clubhouse. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota, dealing up all of your apparently racist needs or whatever with Mickey Mouse ears on or something. I wish I had Mickey Mouse ears for the stream. I wish I did. Oh my gosh. If you haven't seen that picture, I would suggest getting not blocked by some really stellar individuals. And then you can find one of the genuinely funny things they've done lately, which was that. The Mickey Mouse Clubhouse. Okay. Today has been a wild day, right? Absolutely wild. There is blood in the water. There's blood in the water. And I assume that you think that I mean that there's blood in the water regarding Ty. But I'll tell you, there's much more blood in that water than you think right now. And I think somebody out there in the land of anime, in the land of anime kingdomhood or whatever, is maybe just chain sweating right now, and that is very refreshing. And as soon as I can get some more information on that, I will let you know. But we have so much to talk about today that I don't know how precisely to talk all about it. Some really big stuff happened. And then some stuff that looks really big happened that probably isn't. And everybody, of course, hold on, I'm trying to find, that's what I want. Do I have that one pulled in? Perfect. Everybody, of course, thinks that there's some crazy stuff going on, and they've all got their theories, and people are injecting their biases into it and deciding a bunch of stuff that they don't know. So, we're gonna have to. What is this? What is this? Okay. All right, sorry about that. I'm just still trying to get everything organized. So as you know, there were several filings today. I think Jay Sean filed something like 80 pages of motion, not evidence, like of motion paperwork today. So he's very proud of himself. This must be right. Ron Toye was so proudly messaging me over the weekend to show me the brilliance of Jay Sean. I guess Ron hasn't figured out that I lost respect for Jay Sean a long time ago. So, we'll have to go through some of this stuff. But let's see, what's first? What do we deal with first here? Yeah, I genuinely am struggling with where to start on all this. So here's what I'm gonna do. Let's switch over to this one. Ha! This one was a big deal was made about this. And let's talk about this. This is kind of a big deal. It's kind of a big deal, but it's also kind of not a big deal. And that's the interesting thing. Of course, we don't know what it means, right? We know what happened. We know what the document says and what that means. But we don't know what it means in terms of the case. A lot of people are purporting to know. And that's an interesting thing with this. Because especially at this stage of the case, judges get to exercise large amounts of discretion in how they deal with stuff, particularly evidentiary issues in pretrial motions. So we're going to talk about this first. And we'll do some super chats as well, so we're not too far behind. Oh, hey, Ty Beard's in the chat. Looks like Ty is... Ty, what are you talking about? Prepping for a hearing. You don't have a hearing coming up, you liar. The judge threw out your case. Get out of here. He threw it all out. You lost already. But let's start here. Do some super chats, and then we'll keep moving. We'll keep moving and bouncing through some things. I got you hooked on Milo's. I apologize. Okay. So here's the thing. And I suppose just let me respond to the general today. Okay. This is the general today. I did reach out to Ty for comment on the filings, on the allegations, on the affidavits, and all this stuff. And Ty's comment is simple. I mean, he's in the chat. He could tell it to you, but his comment on this was not worried at all. So there you go. He's not worried about it at all. But does that mean we shouldn't be worried about it? You'll have to wait and see, right? You'll have to make up your own mind. Most importantly, the best part is we get the answers starting on Friday. And then as we go, as ruling comes in, we get the rest of the answers. But the answers do start on Friday. I have just realized I have not had any liquid today except for my ramen broth. Is that true? I've had a weird day, guys. I got stung by a wasp twice in my kitchen. Actually, in the kitchen at my old house. Not in my current house. I haven't seen any wasps in there. And I don't know how this wasp got into the kitchen, much less onto my hand to sting me, because I didn't see it at all. And usually Lady Rackets was around, and if Lady Rackets sees a wasp, shotguns come out and start firing at it. So, but I did, you probably can't see it. Anyway, it's on this thumb here. But it's not a big deal. It's a wasp sting, right? It's just a little puffy and swollen. But where I thought I like severed a tendon in my thumb because I was sitting there and I just started going, I felt like something had snapped inside. And it still feels like that a little bit. But I could move my thumb, so I knew that wasn't the case. And then I turned my arm over and I was getting stung right here. There's a little red spot, at least on this one. I'm not complaining too much. My thumb hurts. This one I don't even feel. It's really annoying. I don't know how many wasp stings you guys have had today, but I try to avoid those. And I think they're actually yellow jackets because they have ground nests, which I'm pretty sure like Japanese paper wasps have those paper nests that they make that hang from stuff. And those aren't wasps, or those aren't yellow jackets, but I think the ground dwelling ones are, and those suck. Oh, it's dead. The wasp is very killed, at least. So, anyway, I feel various changes going on in my lungs. Okay, so anyway, sorry. So that was. And I seriously haven't had any beverage today other than this sweet tea right here. I just realized. So I might be a little dehydrated. So if I die on stream, super chat for funeral or whatever. Okay. Let's look at this. So this is a very short letter from Judge Chupp. And an email. It says, find this letter. So Chupp says, Dear Counsel, after reviewing plaintiff's objections to and motion to strike evidence offered in support of defendant Funimation's motion to dismiss, filed on July 24th, 2019, the court finds that all objections are overruled. Okay. So this means that none of the evidence is struck at this point in time. Couple ways to take this. Here's the first way. He's decided not to strike any of the evidence at this point in time. Now, all of this stuff can be brought back up at the hearing. Part of the issue with striking a hearsay or doing a hearsay objection in a pretrial sense is that it's hard to discern precisely what the opposing parties offering the statement for. Because remember, a hearsay objection, hearsay is a statement by someone other than the witness to prove the truth of the matter asserted. But it's hard on motion paperwork to always determine what is the matter asserted. And it also is hard for the defense to get, or the opposing party to be able to marshal up what truth they're at, to argue against it and stuff like that. So Judge Chupp has just overruled all of these objections now. What that does in effect is it says, okay, at this point, they're not objected to. It also immediately gives Ty an appeal point on every single one of those statements that are overruled, or every single one of the objections that are overruled. So it's a weird thing for a judge to dismiss everything just in a letter like this. It's weird because judges tend to be appeal averse. And so this gives Ty 3 appeal points, or not 3, however many appeal points on the affidavits and the specific statements within the affidavits. Of course, if he reversed it or if he had sustained them all, it would give the other side appeal points. So it's hard to really read what this means, but let's take it a step further here. One thing judges like to do is actually see the evidence presented. So he may just want to hear the evidence at court. We don't know why Chupp is overruling these objections and not, making any specific statements about it. So it could be that he just genuinely disagrees with the legal arguments. It could be that he just wants to hear the evidence. You'll find that sometimes judges just want to hear the evidence. No. Learn to grammar, boomer. Are you talking about my title? The and fraud? That's a joke that you have to understand from the Dick Masterson days. So here's how this goes, though. We've got a couple hypotheticals. Hypothetical 1, most likely outcome, judge just wants to hear the evidence presented at the hearing. He wants to hear what evidence the parties are actually going to point to raise their arguments. And he doesn't want just things being struck generally for no reason, right? So let's say he strikes the whole petition or the whole affidavit, but they only had one portion of the affidavit that they needed to use as evidence, and that portion maybe wasn't a hearsay objection, and they only raise that. Or maybe they raise other issues that go along with it, and that portion that is struck from the affidavit isn't actually what they rely on to make their argument. There's a whole lot of reasons why the judge might not want to strike evidence at this point in time, especially when the strikes are so broad. So there you go. So the one thing is he may just want to hear what evidence is being presented at the hearing for the purposes of making the argument. And if that's the case, I would suspect that we're going to see more, that he's going to overrule all of the objections to strike, probably from both parties, on this basis, okay, on the basis of hearsay and stuff like that. Because some of the objections, especially in that document, which was filed back on July 24th, a long time ago, some of those objections are very well founded in law that they should not be included. So if those are brought up again at the hearing to assert some matter, then they'll have an option to reject them, to object to them and reject them at that point. But it looks like Judge Chupp just doesn't want to go out and blanket deny those at this point. There's another hypothetical, and I want to stress, I'm not saying that this is what Chupp wants to do. I'm not saying, but I mentioned the appeal issue. By overruling these objections, Judge Chupp has set up appeal points for Ty should they lose at TCPA. He did not set up appeal points for Lemoyne if they lose at TC, or for, in this case, Volney, if they lose at TCPA. So right now, if they go on and Ty wins the TCPA, the fact that the judge struck the evidence isn't part of Volney's appeal. Does that make sense? So it's a possible indicator, but I would not read too much into this. The possible indicator that he plans on favoring Ty over Volney in the TCPA hearing. This does not apply to the other defendants. This evidence primarily affects Funimation. It might be an indicator of that, because you'll hear this from time to time from lawyers where if it looks like they're being extremely harsh on one party, it's because they intend to be a little bit different. They might be favoring them going into the hearing. It's a weird thing that sometimes happens where a judge will be hypercritical of some things, but then ultimately he's going to rule in their favor. In this case, I don't know if that's happening. I have no information on that at all. This is about all we've seen out of Chupp on these issues. But it is possible that he's eliminating appeal points for the party that he plans to disfavor at the TCPA motion. And of course, even if that's the plan, that doesn't mean that's how he'll end up ruling after oral argument, okay? But that's a possibility. The other hypothetical, so first one is he just wants to hear it. This is the most likely hypothetical. High emphasis on this. The most likely outcome is that the judge just wants to hear the evidence in the context of the arguments. Second hypothetical is that he's trying to forecast that he's currently favoring Vic over Funimation in the TCPA hearing. I would take that very minimally weighted, and equally minimally weighted, I would say that he just hates, Ty, or he thinks that the whole thing is bogus, and just is going to strike it out of hand. I would take that very minimally as well. And the fourth point, the fourth final hypothetical, is that he just automatically doesn't want to strike any evidence prior to a TCPA hearing. So there you go. So that's the possibilities there, and you can make of it what you will. Again, we'll find out on Friday, or if Judge Chupp happens to issue any other letters, because he may come out and say all of the objections on the other motion to strike are overruled too. It'd be very weird for him to strike or to overrule all of them. If he overrules all of the objections to strike, even at the hearing, and then rules against Vic, that would be plainly appealable. That would be very, very weird to see. That'd be weird to see. So we'll have to see at the hearing how that goes. But I wanted to address this right away because people were making a big deal out of it. And yes, the other thing people are making a big deal out of, again, is the notary. So I'll try and circle back on that, and we'll go through some scenarios in a second and try and figure out what the court will think about that. But here we go. Let me get some of these chats out of the way that came in a while back. John Doe says a Lemoyne with a law license is a lot like a mule with a spinning wheel. No one knows how he got it, and danged if he knows how to use it. Hashtag that's so funny would have been a good one too, in my opinion. Limp Lawyer versus Zombie Ginsburg winner. I think Ginsburg could take Lemoyne in a physical altercation still. I think Ginsburg would take him. It's the wasp. Mainly because if you stand Ginsburg's corpse up and it falls on Lemoyne, he dies from it. So that's a shame. That's why I think she wins. Okay, we've got Cesario JPN says plugging that Star Wars Girl 77 / Anna having Hero Hey on her Force Talk show 5 p.m. Pacific time tomorrow, talking hashtag I stand with Vic. She even has a shirt with the hashtag one of us. Also petition Rekieta to invite Anna on a live stream. Maybe. I don't know much of anything about Star Wars, so maybe she could educate me. Oh my gosh, where are we? Tucker says West Nile Chan and Mosquito Coon heroes, patriots, martyrs, legends. Tis a shame they couldn't finish the job. Can I get an F in the chat for these ultimate chads? Oh my god. Talons here says, hey Ronald Toye. Oh my goodness. Next time you and Grinning Gums Rial you take Grinning Gums Rial on a date, take her to a hall of mirrors and show her how she should look. Mythos Irving says Stephanie Nadolny has not said anything about it, but has been liking tweets about the Sabat casting couch leaks. Seems like she's confirming it without confirming it, but Vic's the bad guy, lol. You know, it would be a real shame. It would be a real shame if the result of Monica and Marky and Toye and Funimation doing this, I guess it would be a real shame if it turned out that they were all sheltering an actual sexual abuser. That's their friend that I think the Tuttle group did the mortgage for, all of that stuff. Like, it would be a real weird shame to find out. And I don't know, we'll have to find out, but wouldn't it be just crazy to find out that Chris Sabat withheld roles and threatened to keep someone out of the industry forever and routinely badmouthed a woman to conventions and other employers and said nasty things about her and kept her from getting a job, all because she wouldn't have sex with him like several years ago. It would be a shame to find that out and to have it come out as true, and to have that be all because of this. God dang it, that would suck so bad to have someone who has casting decisions at Funimation be found out to have made those casting decisions based on the sexual or the agreement to conduct sexual activity with him, and then to find out that the friends who supported him, they've got to know about it, happen to be defendants in this case, falsely accusing someone else. I mean, that would be cosmic irony. That would be God smiling down with a giant sunbeam upon this whole situation, wouldn't it? Or a lightning bolt. I guess it depends on your perspective. But think about this. If for nothing else, if that happens, even if Vic loses, then it was worth it. I think everybody on both sides can agree that if this lawsuit, even if everything goes poorly for Vic, but it outed an actual sexual predator who had casting authority over property in the anime community, I think everybody would agree that's a good result, at least. But we'll have to see. We'll have to wait and see. I don't know. I'm still hoping to talk to Stephanie Nadolny. There's another person out there who I'm hoping to talk to that I learned about today, who I've heard. I got some information today that suggests that what Stephanie Nadolny is saying is very credible, and that there's another person with the same story. And I'm looking to talk to that person as well, and I'll be reaching out to them. So we'll find out. Michael Wheeler says, second time with the super chat. Hey, thanks, Michael. Can't wait to get into the ownage of the panic I've seen in the West Nile file today. Oh man, there's a lot of it. Nunya Biz Says the blood is from just how chummy you need to be with Chris Sabat to get ahead of at Funimation. Bros. Jeff Smith says, just wanted to say I respect you more than any other YouTuber. Do something fun with the money. Hey, thank you. And if you can answer, what's your percentage chance on Meyer winning his lawsuit if it goes all the way? Again, keep up the good work. Oh, I think Meyer crushes it on tortious interference. I think he wins. I give it about as good of odds as I give any lawsuit. 75% victory on tortious interference. I give him a 50-50 chance on defamation, just because the nature of defamation and the nature of the statements by Wade are very interesting. But yeah, I think he wins on TI. So if it goes all the way, we'll see. We'll see. Bill Stone says, hi, Nick. Just had surgery and I'm getting paid to lay around getting better for a couple weeks. Awesome. Have some of my Aussie dollary dues. Love your work. First super chat and time I can catch you live. Hey, well, at least catching me live is something that came out of your surgery. I hope it all went well and that you have a good road to recovery. And thank you very much for the super chat and for the view, man. Thanks for hanging out with us. Jeff Smith says, add this chat to my last and take Lady Raggets to a nice dinner. Again, respect your honesty and fairness. Hey, thanks, buddy. And then Kara Papa says, what if Chupp just wants to clear his docket of this petty cartoon crap and tries to dismiss the case because he thinks this is stupid and doesn't want to deal with it? That would be very uncharacteristic of a judge to just dismiss a case, because it'd be appealed immediately. He would have to have grounds of it. So if you want, but he may, I'm going to give you a partial credit on that super chat. He may want to clear his docket of the written filings and say, let's just get to the motion. Like, let's just get past all this petty stuff and get to the motion. So we'll see. Here we go. Okay, so that takes us to the next. That's the next. Oh, wait, let's see. Gong Shubin, I want to address this one. Could Sabat et al. Sue people for defamation who speak out about his casting couch shenanigans, etc., without evidence? Also, free Hong Kong. Yeah, buddy. Liberate for Hong Kong. I don't know how to say for Hong Kong in Latin. But liberty, freedom for Hong Kong. I agree 100% with that. And that's based on my completely uneducated opinion on the matter. But I just know that people who are looking for freedom and a tyrannical state is involved on the other end of it, I move for freedom. That's me. Yeah, he could sue anybody. That's the beauty. People can sue whomever they want for whatever they want. Whether or not he'd win would be the hard question. And I saw someone ask what makes the accusations against Sabat any more credible than what's against Vic. Well, the first thing that's an accusation that's more credible is that the accusation is about him actually requiring sexual activity versus giving hugs to fans. But here's the big thing, right? We don't actually know yet, and I'm not saying that Sabat is guilty of this. I have gotten information that says it's credible, but I don't know. I have not talked to the victims at this point. And until the victims come forward and put on the record what's happened, we won't know, will we? We won't know. So we've got to have the victims come forward. We got to have them lay it out, and then we can all make that determination. I think it would be just the grandest of ironies if it was true. And what I've heard about Sabat from many people inside the voice acting industry is not good. Not good stuff. So that doesn't mean that he, demanded sexual favors for someone, right? Don't get me wrong. I don't know. I've just got the information I've got, and we have to work with it. If he gets investigated, he'll either be cleared or not. If people talk about it, we'll get to weigh that evidence. If people come forward and put things under oath in lawsuits, we'll get to weigh that evidence. So we'll have to see. We'll have to see. I think it's amazing. What an amazing story this is turning out to be. And believe me, if I can bring you any of that information, I will bring you sources. I will bring you documentation. I'll bring you the receipts, whatever I can get my hands on that I can disclose, I will bring to you as soon as I have it. So, and then maybe he'd come on the show and address it. I don't know. We'll find out. Okay, where are we? Here. Let's go to... Should we just jump right into this? Let's do this. Late responses. I think we kind of covered this yesterday. So here is... no, we didn't really... I kind of talked about it, but we didn't really cover it. So this is a leave to file late response to defendant's TCPA motion. This is because plaintiff's response was accepted by the e-filing system at 12:27 a.m. Yeah, Slithering Peanut. You're assuming the women who did it were forced. Stephanie Nadolny refused. That means she didn't. She just got a job out of it. Oh, yeah. I mean, don't get me wrong. There have been allegations of acceptance, too. I just don't know if Sabat was involved in that. The only one I have direct information about Sabat on is the same info that you guys have, that alleged Stephanie Nadolny direct message, which I'm told is authentic, but I haven't heard it from her. So, hoping to clear that up. So we'll find out. We'll find out. I'm trying to get Stephanie on the show, but I don't know if she'll want to come on the show. And then you guys can, that's the best, right? You can determine the credibility by watching the person on the interview. And you can make those questions for yourself. Plaintiff Victor Mignogna requests that the court grant him leave to file a response to defendant's motion to strike roughly 30 minutes after the parties agreed upon August 30, 2019 deadline. Plaintiff's initial filing was rejected for a technical error. See Exhibit A attached, which we'll look at in just a second. Plaintiff's counsel's IT director also surmises that the initial file size of the response, more than 35 megabytes, might have contributed to the difficulty of the document to load into the browsing-based filing portal. Yeah, in Minnesota, let me see what Minnesota e-filing is. Minnesota e-file size limit. Okay. Yeah, here we go. In Minnesota, hold on. So in Minnesota, the maximum envelope size for all of your documents. So in Minnesota, when you do an upload, right, to the e-filing system, you upload each document individually, okay? So you've got your motion, you've got an affidavit, you've got a letter to the court, you've got all this stuff. You upload each of those in a document or PDF format, and then you go ahead and, I think, do they accept PDFs? I think they only accept PDFs. I don't remember. They have format restrictions. I haven't had to file anything in a while, so that's good. But whichever one, you go through and you upload each of your documents, right? And then there's a total size limit on the documents of 25 megabytes, right? So all of your filings for one file envelope have to be 25 megabytes or less. Then each file size has its own limit, which I think is 4 megabytes. So if you have a file, like you have your PDF and it's several pages long and has graphics and stuff, and then say it's 10 megabytes, you have to actually break it up into 3 separate files, because court systems are great and they're fantastic, and government software is always good. So this is 35 megabytes is the initial filing. So that could have caused problems with the or more than 35 megabytes. Could have been the problem with the upload. Don't know. it's not 35 megs of text. It's in a PDF where you might have images that are scanned in. Like if you scan something into a high resolution PDF on my scanner or whatever, even a couple pages comes out to a couple megabytes. So, all right. Might have contributed to the difficulty of the document to load into the browser-based filing portal, as plaintiff's filing deadline is set only via a Rule 11 agreement, and that's important. They technically didn't have to file anything. Plaintiff must be given a reasonable extension of time to complete the filing due to the technical failure. Texas Rule of Civil Procedure 21, if the missed deadline is one imposed by these rules, Rule 11 agreement, the filing party must be given a reasonable extension of time to complete the filing. Moreover, the delay is not due to plaintiff's negligence or that of his counsel, but rather due to technical difficulties outside of their control. Plaintiff's response was accepted by the e-filing system at 12:27 a.m. So 27 27 minutes later. Wherefore, plaintiff requests that the court accept the 12:27 a.m. August 31st filings of his response to defendant's motion to dismiss, or alternatively, grant him leave to file no later than 11:59 on August 31st, 2019, and award him other such and further relief as to which he may be entitled at law or equity. And of course, they filed this concurrently with the actual corrected filing. Here we go. And then here is the submission failure, and the error details. Odyssey file and serve could not accept the PDF file because it's secured by security restrictions. Most common security restrictions include password security, not allowing the copying or changing the document. Please remove the security settings and resubmit the filing, which is weird because they typically don't have security settings on this stuff. And I'm told that wasn't actually the issue, but who knows? So this was 12:15 a.m. But interestingly, so here's the submitted one at 12:27 a.m. Do we have anything on this? Here are the envelope details. I don't know if there's any dates or time on the envelope itself. No, of course not. That'd be beneficial if it said when the envelope was created. Is there an envelope number? Maybe. No. Oh, an envelope ID. I guess I could check when the envelope ID was created. They really wanted to get down to it. Oh, submitted date. Oh no, this is the corrected one. Never mind. Okay. So here's Jay Sean's email. This is at 12:08 a.m. So this is 7 minutes prior to them receiving the error message, and this is something I want to be important. Zed Not Z says, when we mock victims who accuse on Twitter, is it any better to do it on your show? Have I mocked any victims on my show? I don't know. Here we go. So this is 12:08 a.m. So again, 7 minutes prior to them receiving the error message. And I want to point this out. You're late in violation of Rule 11. We will move to strike whatever you might file if you actually file anything. And then, and that's, I guess he sent that as a response to this last email. So then Jim responds, we're having technical difficulties loading the document into the e-filing system due to the file size. Not our fault, but go ahead and make that argument. Sweet dreams. This is at 12:10 a.m. So this is back before they even got the error message from the system. So they can confirm that they were having those technical difficulties prior to the 12:15 time. Here we go. And then he also sent out just 12 minutes later that they had submit the filing. So that's that. I just wanted to go ahead and point that out there. So the way this works, they would have to argue. So for them to be successful on striking these, the response, they have to show that this 27-minute delay prejudiced their clients, that this has somehow caused damage to them, not having those 27 minutes. So I think the simple answer is the judge to extend their response time by 27 minutes. I think that's fair. Let's see. Let's see. Okay. Here we go. Nathan Kish. Oh, wait, no, we got Reborn Exists. Says, hey, Nick, it seems like Jamie is freaking out all over the place on Twitter today. And I'm curious, would you be open up to have Cuck Commander Greg on your show? No. Nope. I will not have Greg Doucette on my show. Sorry, I don't want to give that guy a bigger platform than his failing platform. I don't find him to be an honest engager in discussion. I initially invited him on the show. He did not ever respond to that. And now he's not invited. So, you know, it's too bad. It's too bad. But no, he cannot come on the show. Nathan Kish says, Kick Vic is going mad, trying to explain away the casting couch, saying it affects nothing. I mean, it affects a whole lot of things. Might not have much impact on the case. Could it be used as evidence against a certain person's character and hypocrisy? It depends. It depends. I mean, who knows what'll come out, right? Of the investigations and stuff like that, if there are any that occur. You know, there's a long way to go before we've confirmed any of this stuff. But, you know, should something come out of it that says that other people covered up for him, then it could be a big deal. Here's the biggest deal. The biggest problem Funimation has is that they may have been sheltering an actual sexual predator while throwing Vic out and letting people come to the conclusion that he was a sexual predator based on them not clarifying their statements. So, who knows? That would be a problem for them, mostly in the PR sense. But if they haven't figured it out yet, there's PR going on here. And what they've got over and over again is an ongoing disaster. An ongoing disaster. And I think they absolutely know it. And you can always tell by their reactions what really, really terrifies them. Nathan, oh, wait. Aramin. Hey, Aramin. Erica McCord says, I feel like I ought to give you a little something. Oh, thank you. You've kept me entertained and educated since this whole thing began. Thanks for everything you've done to see justice served. My pleasure. My pleasure, Erica. And stay safe and don't let people get you down out there. I know you're in a completely different land than the rest of us, than many of us. But you know, you're in this. You at least were a part of this industry, and don't let people get down on you for you deciding to speak up. The Big Fee says, didn't they agree to 1.5 to 2 hours for the TCPA hearing? How are they going to get through all of this info if nothing is struck? 2 Sabat reminds me of Kingpin in the first season of Netflix's Daredevil, Bald Devils. I believe the judge has actually agreed to give them the entire day starting at 10 a.m. So I don't think that they're going to be hurting on time limits. I think that was a proposed agreement on the 1.5 to 2 hours for the TCPA that was thrown out by Volney when he was trying to get everything done on motion papers, right? And he didn't whatchamacallit. That didn't happen. That agreement didn't actually occur. I believe it was a proposed agreement by Lemoyne, but at the actual rule, you know, at the actual hearing, that all got tossed out the window. So, and the Schizo guy says, didn't Jay Sean file his TCPA like 20 minutes late? I don't know. He might. No, I don't think so. I think he filed it right in the middle of the day, but I don't remember. Let's see. All right, let's move on here. So we've got supplement to the plan. So here we go. Here's the notice. So this is something I want to point out as well, because this is the big issue today for a lot of people, at least the big issue that I saw. And I tried to address this a little bit last night, but we've got some more info today because we've got some emails and we've got Jay Sean Lemoyne whining about it. And that helps kind of flesh out what happened. And that's in regards to the affidavits of Chuck Huber, Chris Slatosh, and Vic Mignogna. All right. Here's something important. 1:30 a.m., September 3rd, 2019. So that's today at 1:30 a.m. Now, did this actually get filed at 1:30 a.m.? No, I don't think so. If you'll notice, this was filed at exactly midnight today. This was filed 1:33 a.m. The second amended petition. So this is, the system is processing all of these filing things in the morning here, but it still gives us an idea of when these things occurred. 1:30 a.m. So this is actually filed, I believe Sunday. This was filed, but because, you know, Labor Day has to happen, then someone has to come in and sit down and review these things and actually approve the filings. Make sure there's not some facial defect on the filings. The clerk has to go through it. They're going through their queue. Okay, so this is filed at 1:30 a.m. today. We'll find out, of course, that the defendant's stuff, 11:30 a.m., 12:15 p.m., 3:13 p.m., 3:25 p.m., 10:12 a.m. Yeah. So this should tell us that this occurred before anything else occurred. Okay? That's going to probably be important. Let's see. To the Honorable Judge of said court, counsel for plaintiff Victor Mignogna hereby notifies the court and opposing counsel that plaintiff is withdrawing the affidavits of Victor Mignogna, Chuck Huber, and Chris Slatosh that were attached to plaintiff's response to the defendant's TCPA motion to dismiss. So they did withdraw these things prior to any complaint being lodged to the court. That matters. All right. Which one do we have here? Omnibus rejections. Where's their sanctions thing? Oh, dang it. I just deleted that. Is this the sanctions one? This is it. Okay. Okay, right. Yeah, this is it. Okay, let's go. I want to go through this one because this is the one. This is the one that I can see Jay Sean furiously masturbating about, being very proud. Very proud of this filing. And let's talk about this. I'm not wrong. SN, with respect. That was done via email. I said brought before the court. It's what's brought before the court. All right. Next. Ilhan Omar's husband wants a divorce after a bombshell. He needs a Minneapolis lawyer. I know some good divorce lawyers in Minneapolis. He can talk to me. I'll help him out. Okay. Here we go. So defendants Monica Rial, Ronald Toye, and Jamie Markey's joint response / cross motion to strike. First, the plaintiff's response to the TCPA motion to dismiss. Second, plaintiff's second amended petition. And third, deny plaintiff's motion for leave to file late response to defendant's TCPA motions to dismiss. Defendants Monica Rial, Ronald Toye, and Jamie Markey, collectively defendants, hereby file this joint response and cross motion to strike. I just read that. Due to technical issues, and respectfully request that the same be stricken from the record and or disregarded in whole. Introduction. It appears that plaintiff's counsel Ty Beard falsely notarized the affidavits for 3 witnesses, including plaintiff. Conduct which rises to a fraud in the court. Let's talk about this as we go. I'm sorry. Hiccups. The witnesses are Vic Mignogna, resident of Tarrant County, Chuck Huber, resident of Tarrant County, and Chris Slatosh, resident of Ector County. All 3 men, the affiants, purported to execute affidavits in Tyler, Texas on August 30th, 2019, right before the kickoff Labor Day weekend. The fraudulent affidavits. So that's cited. Conduct which rises to a fraud on the court is not cited. And there's a reason that there's no citation for this. A criminal offense in the state of Texas. Well, a fraud on the court would be a criminal offense in the state of Texas, but you notice that there is no citation which suggests that what happened was actually a fraud on the court. So we'll have to see. Now, let me preface this. I'm going to go through this. We won't know what the judge will actually do. If you conclude that this is criminal fraudulent activity, go ahead and conclude it's criminal fraudulent activity. If you conclude that this is nonsense, go ahead and conclude that it's nonsense. We'll find out pretty soon what the judge thinks about all of this. But I think personally, Jay Sean has made a mistake here. And I'll show you why as we go. Okay? Here we go. The undersigned gave Mr. Beard an opportunity to explain himself. So that's Jay Sean saying, see declaration of Jay Sean Lemoyne attached here to his Exhibit A at paragraph 28 in Exhibit 3. Rather than offer an explanation, Mr. Beard caused plaintiff to file a second amended petition with declarations from plaintiff, Huber, and Slatosh. By attaching declarations to the second amended petition, Mr. Beard hopes to avoid the striking of the fraudulent affidavits and utilize the provision of the TCPA that requires the trial court to consider pleadings and affidavits. See Texas Civil Practice and Remedies Code. In determining whether a legal action should be dismissed under this chapter, the court shall consider the pleadings and supporting and opposing affidavits stating the facts on which the liability or defense is based. Of course they will. Of course they will. I think Jay Sean has specifically said that the pleadings are evidence, right? This is an instance when the integrity of the court is threatened by the behavior of a licensed attorney in the state of Texas. It's a bold claim. And 3 witnesses willing to participate in his schemes. So this is very interesting here. And this is where I think Jay Sean is overplaying his hand. He's suggesting that 3 witnesses and a lawyer are party to what he called criminal activities in the state of Texas. That's bold. That's very bold. Severe sanctions are warranted, including the striking of the response, motion to strike, and second amended petition. Plaintiff filed his response to blah, 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 and objections and motions to strike, all this stuff. Now, notice, again, he provides, at this point, no citation for why this should happen, but this is just the introduction, so let's keep going. Let's keep going. Relevant factual background. On August 30th, plaintiff was required to file the response to motion to strike pursuant to this court's order and Rule 11 agreement. Plaintiff missed the deadline and filed the response on August 31st, only after a prompting from Ms. Rial and Mr. Toye's counsel. That's a bold claim, too. It's actually not a true claim. So, if you're going to call out opposing counsel on a mistake or something you say is bad, don't make an untrue assertion. This one is very bold. The prompting from Lemoyne caused them to file. You're right. Actually, no, he's 100% right. What they should do is they should go into Judge Chupp and they should say, you know what, Your Honor, you're absolutely right. At 12:08 a.m., when we got Lemoyne's email, we realized we should draft the document and file it. And then we got it filed by 12:27 a.m. That's what they should say. That makes sense. So they got that filed in 19 minutes. They drafted a 40-page document, added thousands of pages of, or 1,000 pages of evidence, and then they got it filed in 19 minutes. And that's what happened. Very, very weird to come out with this strong wording on this stuff when you can't prove any of that. But you could say that they missed the deadline. You'd say they missed the deadline and you know, the deadline that they set, this is what you do, the deadline that they asked for, all that stuff. You argue that. You don't go ahead and go that extra step of accusing the other party of doing something unless you could be darn sure that they did it. So then they've got the citation from his declaration, okay. Trouble Lord says, this whole Vic situation reminds me of rules for radicals. Accuse your enemies what you are guilty of. Very often. To put it mildly, the response is a disaster with multiple glaring mistakes, including even incomplete footnotes such as the following. Hey, Lemoyne, I got news for you. Did you read your own TCPA's footnotes? This is funny. Actually, Ty, if you're still watching this or if you happen to see this later, will you please bring up to Chupp that Lemoyne's footnotes and his TCPA are an abject disaster, unmitigated ruination. They're citing to the wrong evidence. They're citing to things that aren't there. They're citing to evidence that doesn't say what they say it says. I mean, I don't think West Nile Chan is the person to be accusing Ty of having this. But either way, this has been corrected in their in their amended pleading. So Ms. Markey's counsel quickly recognized that something was amiss with the notary and made demand for Mr. Beard's notary book. On August 31st, plaintiff filed the motion for leave, alleging the response and motion to strike were late because of technical difficulties. Notice he keeps saying August 31st. When was that filed? Oh, we don't have it. This one was filed 12 a.m. So this was filed like immediately. Let's see. This one was I don't have the filing one. Where's the filing one? I don't even have the filing one. But this was filed like immediately. So he keeps saying it technically was on August 31st. However, it was filed right after the other thing got filed. So anyway, yeah, this assertion is not supported by the e-file system time entry, and given behavior of opposing counsel should not be accepted at face value. Again, this is an extremely bold statement. Extremely bold statement. Why you're telling a judge that he should not believe another attorney when there's email to back it up and there's an error message to back it up. I mean, this is, whew. Wow. I mean, Listen. Accusing opposing counsel of misrepresenting something to the court. My experience with that has not been super positive. Judges don't like that unless you can show it. That's just not something you should do. Accusing them of making a mistake and a mistake that prejudices your client, go ahead. Saying that the judge can't trust the other counsel when you're about to go into a hostile hearing, the judge is going to necessarily have to correct that assertion in his head to remain neutral. You probably have increased Ty's credibility in a weird way. Good job. On September 2nd, undersigned counsel gave Mr. Beard an opportunity to explain what occurred. You tell me what happened. Oh, God. Wes Nile Chan says, what? Footnotes? I heard my name. I was too busy playing my favorite game, Legend of Lemois, Breath of the Nile. So here's his, Mr. Beard, I'm gravely concerned that the affidavits of Vic Mignogna, Chris Slaytosh, and Chuck Huber were not signed in your presence, despite the representation in your jurat, see below. While it is possible that all three drove or flew to Tyler so that you could personally execute those affidavits, it's highly unlikely. I've confirmed Mr. Slaytosh was at the San Japan Anime Convention on August 30th.
Obviously, you understood the import of Mr. Johnson's request for your notary book when he sent his letter on August 31st, 2019. Obviously, a photocopy of the notary book would be some evidence to support what occurred. Perhaps there is an explanation, but I am struggling to determine what it might be. But before I file a motion with the court, I wanted to give you the opportunity to take a position. Assume the position. I will wait until September 3rd, 2019 at 10 a.m. for you to provide your side.
Of course, he responds to this email, and we'll get to that. Rather than explain the mystery of how Mr. Beard notarized 3 affidavits in Tyler, Texas for 3 witnesses that each live over 100 miles away from his office, he filed a second amended petition at 10:20 p.m. on Monday, September 2nd, 2019. And that's Declaration of Lemoyne. The second amended petition,
I cite to my own statements to make my statements.
The second amended petition appears to be an almost mirror image of the response. Actually, no, it's significantly different than the response. It's almost a mirror image of the first amended petition, except that it's got a new section added to it that is roughly 1/6 the size of the other filing. So no, it doesn't actually mirror the response. It's a much condensed version of the response. So again, he's being disingenuous, and this is stuff that Chupp could look at. Isn't that hard on your voice? That's actually not that bad. Tugger says, I'm not going to lie, Nick. This is straight up amateurish on Ty. Come on, man. First of all, I've not said that this is not amateurish for Ty. In fact, last stream I said several times that the filing was sloppy, that it wasn't good. I said that it doesn't ultimately matter. And we haven't even discussed what happened yet. We're still reading this. So chill out, relax. My point right now is we're addressing Lemoyne's response to it and why his response might be a problem, in my opinion. Actually, I think it's a big problem in my opinion, but you make your own decision. So here we go. Second amended petition appears to be almost mirror image, but it's not an almost mirror image. That's not a true statement. It has some of the same arguments are borrowed, but it is limited to what is what a petition looks like rather than what the response to the thing looks like. But that's okay. You can actually do that, and several practitioners do that. Many practitioners don't actually file a response to the TCPA. They just amend their pleadings and go with that for this very reason. Ryan Mercado says, how bad would it be for the defendant's counsel if Ty proves that the affiants were there personally to sign their affidavits in Ty's presence? One, it wouldn't be bad. It wouldn't be bad for them at all. Two, I don't think that it matters. It's moot because the affidavits were withdrawn. So, but we're getting to that. Let's see. Even Ty said it was sloppy. Okay. Let's see. The second amended petition has 427 pages of attachments with exhibits A to Q, which include declarations from plaintiff Mr. Huber and Mr. Slatosh, and the condensed depositions of Ron Toye, Monica Rial, and Vic Mignogna. It appears that with the extra 2 days, plaintiff was able to fill the footnotes missing in the response. See, this doesn't actually help Jay Sean's case, right? Like, he's taking a jab here. And I mean, I guess you take a jab, but what if the missing footnotes happened because they were attempting to correct the technical error? I mean, maybe that's what happened. We'll see. A little before 1 a.m. on September 3rd, Mr. Beard finally responded that the fraudulent affidavits were mistakenly submitted with defects in form and threatened sanctions if his fraud on the court were disclosed. Now, this is interesting because he attaches the email and there isn't actually a threat of sanctions if they're disclosed. There's a threat on sanctions for something else completely, or maybe it's not a threat. I don't know. It doesn't. We'll see. Again, you guys, I'm trying to I'm trying to let my personal opinion back up a little bit. I mean, you guys obviously know my personal opinion. My biases are out there, but I'm trying to let that back off for a minute on this stuff. So there has been no fraud. The affidavits were mistakenly submitted with defects in form. This is my notice that we're withdrawing them. I'll serve notice tomorrow, but this email is sufficient notification. So this is date September 3rd at 12:47 a.m. So here we go. No harm has been done to your clients, and the declarations in our second amended petition are identical to the defective affidavits with one very minor exception. Mr. Mignana's original affidavit incorrectly stated that he was prescribed Losatrin as a result of the acts of the defendants, so that statement has been omitted. Otherwise, the declarations have the exact same statement as the affidavits. Of course, there's no need to do that since we've told you we're withdrawing them. So the affidavits haven't actually caused them any harm. This is where the ultimate crux of the argument is. They submitted affidavits that were defective. They've admitted that they're defective. They've withdrawn the defective affidavits. The judge hasn't ruled on the affidavits. No argument has been made on the affidavits. And they told them prior to their filing of their paperwork, so they didn't have to do any work in regards to these affidavits. That's just how it goes. So that's why I think this is ultimately a problem, because the judge is going to ask, what harm was done to your client because of these faulty affidavits? That's what he's going to ask. And Lemoyne's not going to have an answer for that. How are they harmed? Specifically because the declarations are virtually identical to the affidavits. And that's even admitted to by the defendants in their, what is it? Here we go. These objections apply to the new declarations of Chuck Huber, Chris Latosh, and Vic Mignana. The objections apply because they're identical. So how did this prejudice your clients? How does this cause harm to you when they withdrew the affidavits prior to the court doing any action on them? And ultimately, that's the issue that we're going to run into with the notary. At the end of the day, who bore damage from the defective notarization? If there was a defective notarization. They say defect in form. I'm going to read that to infer there's a defect in the notarization. Okay, so defect in notarization occurs. They withdraw the document. The opposing counsel notices it. They withdraw the documents, say, whoops, these are defective. We didn't realize it. We withdraw the documents. They submit the unsworn declarations, which you can do. You can submit unsworn declarations. In fact, I believe Sam Johnson submitted an unsworn declaration in support of his TCPA. So there you go. So now that we're withdrawing them. And if you want to get into a sanctions fight, so be it. Now that's interesting. He doesn't threaten sanctions here. He says, if you're going to pull into a sanctions fight, okay. However, given your client's rampant discovery abuse, which still is unresolved, they haven't asked for sanctions for, they haven't even fully asked for relief on that. For instance, Rial testified several times that she gave important information to her counsel that was not produced to us. Revealing of sensitive information about Mr. Mignana in your pleadings in violation of TCRP 21C. Your numerous violations of TCPRC 13 and 10, etc. I don't think you're going to get much traction with the court. And now that you have noticed that we're withdrawing the defective affidavits, we will of course argue that filing motions to strike will violate rules 13 and or 10 if filed. So there you go. They can make that argument. That's not actually threatening a sanction. If this reminds me of the arguments that Kevin Landau used. These are a little closer to the truth than Landau's, because Landau is just comically bad. But these remind me of Landau's arguments for sanctions when they said, look, you've got this much time to report it to the court, or we're gonna have to. And then Landau said, they threatened to report me to the court. That's sanctionable. Okay. There we go. Shortly thereafter, around 1:30 a.m., in what is an obvious admission of guilt, Mr. Beard withdrew the fraudulent admissions. Guilt of what? Guilt of what? Now is the appropriate time to determine what traction the court believes is necessary for Mr. Beard's actions. Arguments and authorities. All right, let's see some citations. Let's see some citations. The court should strike the response and the motion to strike for failure to comply with the court's order and the party's Rule 11. They're not. This is such a failing argument because the rules allow for technical difficulties. Judges have dealt with technical difficulties. Everybody who has e-filed anything has dealt with technical difficulties because the e-filing systems are written for government. They're paid for by government. So here's what you need to know about them. They cost more than they need to cost, and they run worse than they need to run every single time. You deal with courts at all, and you'll find that all of their software is absolutely bananas terrible. Okay. On August 31st, 2019 at 12:08 a.m., counsel for Ms. Rial and Mr. Toye emailed all counsel pointing out the plaintiff had missed this agreed and ordered deadline, and defendant's clients would move to strike any late pleading. Counsel for plaintiff responded, alleging trouble due to file size, and encouraged opposing counsel to have sweet dreams. Look at this. He's so butthurt about it. He's so mad. Even though he ignores that in his email, if you file anything at all, was an obvious barb. It was an obvious barb. But plaintiff did not even submit the response in its unfinished state until 12:15 a.m. This actually, I'm told, isn't true. I'm told this is when they received the error message, not when they first submit the document. So, I don't know. I don't know about that. Tugger says, of course, Lenoir is straight re-arted, and his arguments seem ridiculous. I just wish Ty was a little more careful. It could be part of the story I'm missing, so I'll lay off for now. Tucker, here's what I'll tell you. Ty's not a guy who makes excuses. So there are a whole bunch of reasons. There are a whole bunch of reasons that play into why one filing might not look as good as other filings and why things might look bad on a particular day. And I'll just say this. The practice of law, and this is something that Law Twitter is ignoring, the practice of law is a fluid thing involving lots of real people who have lots of issues that go on. You've got tech, you've got distance, you've got communication, you've got health, you've got scheduling, you've got other matters, you've got all sorts of things that play into why a particular filing could be a problem on a particular day or why something might appear sloppy. But here's what clearly happened. They filed the stuff when they could. There's a tech issue, and filing at the last minute is something lawyers do all the time. All the time. Make no mistake. Like, there's no, I know Law Twitter is like, oh, maybe you shouldn't wait till the last minute. Lawyers do it all the time because you're keeping on drafting your stuff until you're done. Till you say, okay, I've got to submit my stuff. There's just no more time to do it. So there's no real issue with waiting till the last minute. But here we go. You've got a whole bunch of stuff factoring into it. It's the deadline is coming up, and sometimes things don't happen right on the day of the deadline. They filed what they had done. They filed their response. The response has some issues with it. It is sloppy. It's not the best work. And then they updated their pleadings with the same arguments, the same information, and the same evidence, but the language is refined. It's cleaner, and they should be allowed to actually do that. They should be allowed to amend the pleadings because the Rule 11 agreement says nothing about amending pleadings at all, actually. The Rule 11 agreement is only the response to the motion or the motion to strike and the response to the TCPA. That's what the Rule 11 agreement says. Nothing about amended pleadings. And Jay Sean Lemoyne is a TCPA expert. He knows that amending pleadings is part of the process. And as long as the amended pleadings don't include any new causes of action, there is no prejudice to the defendants. Now, they may need to request leave from the court to amend the pleadings. that's kind of up in the air and ambiguous right now. If I were them, I would, but I don't know what they'll do. Obviously, they have the case law at their fingertips and they can deal with that. But we all of us commentators, me, Law Twitter, you guys, we all have this unique, not unique, the non-unique position of being able to look back on what someone did and talk about it. And that means that there will be some times where we have to call them out for sloppy work, and we can either ignore the reasons that led into the sloppy work, or we can delve into them. But Ty hasn't made any excuses for the sloppy work, and I've tried not to make any excuses either. So, because at the end of the day, it's either sloppy or it's not. And yeah, but let's just go. Let's just go. Here we go. Did not even submit the response. Okay, plaintiff's counsel certified that service of the response did not occur until August 31st. Well, yeah, because if he certified otherwise, you would say he was lying. Plaintiff did not submit his response until the day after the deadline. Well, I mean, 27 minutes. Despite his insistence that the failure to comply with the court's deadline was due solely to technical difficulties encountered on August 30th. The amateurish, unfinished nature of the response indicates that it was not complete at midnight on August 30th, 2019. See, again, I think he's overplaying his hand with this. Overplaying his hand with it. See response. Okay. Plaintiff relies on Texas Rule of Civil Procedure 21F6 to excuse his late filing. If a document is untimely due to a technical failure or a system outage, the filing party may seek appropriate leave from the court. If the missed deadline is one imposed by these rules, filing party must be given a reasonable extension of time to complete the filing. But if the evidence submitted shows the attempt to file was late and not caused by some technical problem, oh, I see what he's saying. He's saying that 12:15 shows that that's when they submitted it. But at 12:10, 5 minutes prior, they had already said they were having trouble with the file upload. They also, I'm guessing, have several people in the office who can under oath state that they were having trouble with the upload prior to midnight. But, you know, that's just me. Then you're going to have to assert that all of these people are lying under oath. Again. Okay. Then this rule does not justify an extension. Plaintiff may very well have experienced technical difficulties when he filed his response on August 31st, but this does not excuse the fact that he missed his deadline, an extended deadline that he requested a month before, having failed to lay proper predicate, and the fact that the evidence shows the attempt was made after the deadline. The court should deny this request. I mean, I wonder if Ty could produce affidavits or sworn testimony from his staff that say that they tried to do it before 12 and had a problem with the file size and had to resize it to go ahead and fix it for the court, for the filing system. Or more likely, Judge Chupp will just say, everybody has trouble with this stupid filing system, and this is 27 minutes, and you're not going to get this. Further, given plaintiff's participation in the fraud on the court, he's not entitled to any benefit of the doubt from the court. Again, this is very conclusory and very bold. But Jay Sean's feeling confident here, so there we go. Yeah, here's this. Someone said editing. What was it? It was something like editing. Yeah, file uploading while editing is some heavy level stuff. Yes, so they weren't done by 12:27 when they finally filed it, but they definitely tried to file it at 12:15, I guess. Fraudulent affidavits are a deliberate fraud on the court. If, as suspected, the affiants did not appear before Mr. Beard, then the fraudulent affidavits to the response are inadmissible and constitute an attempt to commit fraud upon the court. See Allison versus Conglomerate Gas. Let's check this out. Moreover, although an affidavit is not required to have a jurat affixed to meet the statutory definition of an affidavit, the purported affidavit contained one signed by the notary stating that wife had both signed and sworn the affidavit before the notary. Thus, even if Governing Code Section 312.0111 does not require an affiant to swear to the affidavit's truth in the physical presence of a notary, the juror on the purported affidavit falsely claimed that the wife had done so, describing juror on purported self-proving will as false when witness did not sign this in notary's physical presence as stated in the jurat. Let's see. What is the citation? What is this here? Where's this footnote from? Okay, this is justification of mistake. Dismissing appeal after concluding motion was untimely filed about 5 minutes late when appellant did not allege or prove that the motion was transmitted to appellant's electronic filing system provider before midnight, or there was a technical failure or system outage that caused the untimely filing on his motion to extend the time to file his notice of appeal. So again, I think they can go ahead and probably just provide an affidavit from their tech guy that says this is what happened. Here we go. If a written statement does not meet the requirements of the Texas Government Code, it is not an affidavit and cannot be admitted as evidence. That's Mansions in the Forest LP versus Montgomery County. But see, they're not trying to admit the affidavits as evidence. They acknowledged the defect and withdrew them. Not only are the fraudulent affidavits inadmissible, making false representations on an affidavit are criminal acts by both the affiants and Mr. Beard. See Martin versus Frail. And this is 18. In Texas, a notarized certificate to an affidavit is not valid if the affiant did not appear personally before the notary. Indeed, as discussed in a case cited by the individual defendants and as addressed in Exhibit 6 in their response to Martin's motion to file a corrected affidavit, falsely notarizing a document can result in criminal sanctions. Can. It is, of course, true that to constitute a notarial certificate to an affidavit valid, the affiant must appear personally before the notary, absent which the certificate is false and its execution a criminal offense, not only on the part of the notary, but on those participating in the commission of the crime. So, there you go. Of course, one thing that's missing in all of his accusations is any sort of... Criminal accusations in civil matters are extremely difficult. Criminal accusations in a motion like this, absent a whole lot of evidence, are extremely tenuous as well. They commit a crime. Criminal accusations, of course, have the much higher standard than anything else. It's not just about convincing a judge that you think they committed a crime. You would have to actually go through the evidence or go through the process of a criminal accusation. And that rules out one big possible problem: a mistake. A mistake. A fraud on the court is an intentional act. It's an intent to defraud the court. You have to try, right? Like, just doing something by mistake isn't necessarily a fraud on the court. You'd have to prove beyond a reasonable doubt that there was some sort of scheme to get it past the court's notice or something like that. That seems unlikely when someone withdraws something they found to be defective and submit something different. But that's me. The typical sanction, in addition to attorney's fees, notice that's not cited, I don't think, for false notary jurat, is that the fraudulent affidavit should be struck and disregarded. The fraudulent affidavits don't exist because they were withdrawn. Tugger says, hasn't Jadolf ever sent an email into an undeliverable email address? It takes several minutes to bounce back. Smart one, disingenuous argument, Führer West Nile. Yeah, I know. So here we go. Oh yeah, the addresses are in here. The addresses are, this is Lemoyne filing addresses of witnesses. Might be a violation of the rules. I don't know. The distance between Mr. Beard's office and the residence of each affiant, as stated in their respective fraudulent affidavit, is significant. Slatosh, Huber, plaintiff. Let's see. In Texas, a notarized certificate. Oh, wait, I read that. So, as calculated using maps.google.com, the Slatosh affidavit does not identify his address. However, filings with the Texas Comptroller for Silverfire LLC identify this as the mailing address associated with this entity. So there you go. Lemoyne's history of doxing continues. All three affidavits attest that they were allegedly signed in front of Mr. Beard. Based on tweets from Mr. Beard's Twitter handle, it appears that on August 30th, Mr. Beard was in the office of Beard Harris Bullock & Hughes in Tyler, Texas, consistent with his jurat signature. It strains belief that the three affiants, each over 100 miles away, appeared before Mr. Beard to execute affidavits that could be executed in any city with a bank or lawyer. This is buttressed by the belief that Mr. Slatosh has been in San Antonio, Texas since at least August 29th, 2019, to attend San Japan, an anime convention at the Henry B. Gonzalez Convention Center. Lemoyne Declaration. Mr. Beard's failure to respond when directly confronted with accusations of criminal behavior, in particular as a licensed attorney, are indications that he falsely notarized the fraudulent affidavits. Now, this is interesting. This is very interesting. This is an attorney. Think about what this attorney just said. Think about what this attorney just said. Failure to respond when directly confronted with accusations of criminal behavior are indications that he falsely notarized the fraudulent affidavits. I'm sorry. Wait a minute. I thought that we had... is there some sort of thing out there? Is there some sort of thing out there? What is it? What's it called? Constitution. That's right, a constitution. And there's something called like an amendment. There's at least 6 of them. Amendments. Oh, there we go. I think it's the 5th Amendment, right? That says that that first of all, you don't have to make any self-incriminating statement. So, ignoring the fact that I think that 0 criminal activity occurred here, the idea that he would include an argument so blatantly affrontatious to the 5th Amendment in a serious manner. Well, he didn't say anything when I accused him of criminal activity. I mean, come on, Lemoyne, what are you talking about? You think Chupp's not going to recognize that this would definitely be a 5th Amendment argument if there were any criminal activity asserted in any credible way, that there would definitely be a 5th Amendment argument to not say anything to you? Oh my God. But again, he's going too far. He's going too far. You don't have to go to criminal activity, but he's trying for those sanctions. This is the crux of it. He's trying for the sanctions. Why is he trying so hard for sanctions? Probably ain't getting paid. Plaintiff's counsel has withdrawn the fraudulent affidavits. Oh, finally, something honest. Tucker says, wait, so you can now be compelled to testify against yourself? That's stupid. And you missed my earlier chat when I was all humble and apologized, Raggets. Did I? Oh, there it is. There it is. I did. I'm sorry. It says, lol, the Fuhrer is upset that the meanie lawyers got a good shot in on him. And yeah, I'm being too harsh. I think I owe an apology to Ty. You don't owe an apology to Ty. Be harsh on him. He deserves it. Essentially admitting to his misconduct. And again, just so you know, guys, typically in a civil case, correction of, let's say a negligence case, correction of a defect. I got it. Someone is walking on your bridge. There's a slat that they fall right through. Okay? They fall right through a slat. All right? And they die. And their family sues you for wrongful death because the bridge is over the Grand Canyon or something. Very big bridge. They fall through a slat because you made a wooden bridge over the Grand Canyon. And they die. Now, during the pendency of the action, while they're suing you for wrongful death, you go out and fix the slat. That is not actually an admission of evidence of negligence and can't be used to prove the negligence of the prior incident. Correcting something that you find to be an error doesn't actually prove that you were negligent in the prior thing. So again, he's making these things that are contrary to actual legal arguments. They're contrary to actual legal arguments. Imagine this. You carry your gun. You're driving with your gun. okay, across state lines. You cross into a state like New Jersey, where your carry permit from some other state isn't valid. Okay, so you're driving your gun, or you're traveling, and you transport your gun, and the gun is in your glove box. All right. Now you get to the destination state, and your friend says, "Oh, by the way, you shouldn't have that gun in your glove box. That's something you shouldn't do." So then when you drive back through, you put it in the trunk in a locked safe or whatever. Did you admit to committing criminal activity? Did you intentionally drive with your gun in the glove box? Did you intend to violate the statute at that point? Did you admit misconduct because you corrected something? No. Again, these are weird. These are weird arguments for an attorney to make. But this does not erase his sanctionable conduct or his violation of his oath. His oath, Texas Government Code annotated. Further, the court should note that plaintiff's counsel, specifically Mr. Beard, and then this, again, I can't focus on how bad this page actually is. We have someone who doesn't understand the Fifth Amendment. We have someone who doesn't understand how rectifying a wrong doesn't actually make an admission to the wrong. And then here we have a violation of what would be a rule of evidence, right? Plaintiff's counsel, specifically Mr. Beard and Mr. Bullock, have been sanctioned for fraudulent behavior before a Texas court in the past. Whew. Whew. That is bold. So he goes ahead and brings up, by the way, they're waiting on the response from the other party. Ty can't actually comment on this case because this case is pending a Supreme Court petition. And part of that Supreme Court review involves the sanctions that they have claimed are improper. So he's bringing up a sanction of other activity to prove that it occurred on this date. And that is very, very bold. In this original proceeding, Ty Beard, Jim Bullock, Brian Casper, Craig Doherty, and Don Harris seek mandamus relief from the trial court's April 22nd, 2014 order directing them to pay attorney's fees to the Deborah Patterson Howard Trust as a discovery sanction. We deny their petition for writ of mandamus and dismiss their motion for emergency relief as moot. However, wait, did he? No petition. Hey, Ty. Hey, Ty. He says that you haven't petitioned for cert on this. You out there, Ty? Oh my goodness. He says that you have not petitioned the Supreme Court, so that's pretty interesting. Let's look it up. Luckily, looks like a typo. No, Ty's still here. I see him. Hold on. Let's just go ahead and change this. What is it? We got 12 down. Oh, wait. WL 273-187. Just waiting for loading time here. Yeah, they say no petition, Although I'm pretty sure there's a petition here. I'm just trying to figure out if it says it on Westlaw. This is very, very interesting. I don't think it has. No, it's been cited a couple times, but it's not. I don't actually have the petition. I don't have access to it, but that'll be interesting because, of course, they can point out that they have petitioned. Can't you just set it up to make a clang when I post something? That would be great. I can't. You give me too much credit. Yeah, I wish I had. Let me see if I can find it. I don't know how to find this as easily here. I wonder if the Texas Supreme Court has it. I don't know why I'm focused on finding this right now. It's just interesting to me. Let's see. Can we find case search? Oh gosh. Ty, I don't suppose you have that case number that you could send me. Yeah, I know we've talked about this on the show before. They've filed for petition and the other side is supposed to brief or they petitioned for writ of certiorari. And the other side has to issue their brief sometime in like 7 more days. But yeah. So anyway, I could text him. Oh wait, I just gotta. Oh, here we go. Where did we get? Where is it? Farms found it. Here we go. Perfect. Let me thank you, Kiwi Farms. Those guys so much better at everything than everybody else. Just people don't really like what they're better at than them on. Here, I'll pull it up. So this is the Court of Appeals one. I'm trying to find the Supreme Court one. 19040. Case search 19 dash. Let's search. Here it is. Here we go. Oh, I see. Okay. Here's why they don't have it. So we'll give Lemoyne credit. I'll pull up the case detail for you. You guys can see this. We'll give Lemoyne credit. And say maybe he just missed it. So here's the petition for cert from the Supreme Court of Texas. Now the petition is Deborah Patterson Robert H. Patterson Jr., trustee of the Deborah. So Deborah Patterson versus Robert H. Patterson Jr. So this is the underlying case where the sanctions were administered. The underlying case where the sanctions were administered. Let's see. Response requested due on the 5th of September. So tomorrow, the opposing party has to file their brief. Here's the petition for review. So those sanctions have been appealed, but NRE Beard was not appealed. So we'll give Lemoyne credit for that. I'm sure Ty would like to correct him at the hearing that this is a matter that's pending review in front of the Supreme Court of Texas. So there you go. So here's the order granting motion for sanctions. The court should strike the second amended petition. Plaintiff desperately wants a continuance, which is interesting because nowhere have I seen the plaintiff ask for a continuance. Nowhere at all have I seen that. But what I have seen is the defendant suggests that they wanted the plaintiff to ask for a continuance in their motion, opposed to the motion to strike. Which I should say their original motion opposed to the motion to strike was actually filed prior to the motion to strike. Very weird. Very weird. So plaintiff desperately wants a continuance. Respectfully, the court should not give him one. Again, a weird overplay. The plaintiff has not requested a continuance anywhere. Nor allow him and his counsel to make a mockery of rules designed to stop perjury and other fraudulent behavior. Further, even though the TCPA does not have set deadlines for response, this is not a justification for trial by ambush. How are they being tried by ambush? Let's see. The absence of a rule directly applicable to an issue should not be used as a means to ambush opposing counsel. Instead, in the absence of a rule, trial court should have the discretion to determine the timeliness of a response. So, again, the question is, what are you being ambushed by? What new issue is raised in the petition that you're not prepared for other than those declarations? Can't say affidavits now. Those declarations have ruined your case. Huber's affidavit, Vic's affidavit, and Slaytosh's affidavit, or declarations, I should say. Huber's declaration, Slaytosh's declaration, and Vic's declaration absolutely demolish the TCPA in regards to Real and Toye. Specifically Slaytosh's. Slaytosh's kills it outright. And they know it. And they know it. Instead, in the absence of a rule, the trial court should... Yeah. To the extent plaintiff intends to rely on the second amended petition, the 427 pages attached thereto, it is a violation of the Rule 11 agreement. Is it? Let's take a look at the Rule 11 agreement, shall we? Because we're gonna have to get into this Rule 11 agreement, aren't we? Rule 11 agreement. Go ahead and pull it up. Oh my goodness. Open it. Here we go. Rule 11 agreement. Let's take a look. Maybe Jay Sean is right. What do I know? What do I know? Under Rule 11 of the Texas, this will confirm our agreement regarding scheduling matters. Plaintiff will file his responses to the TCPA motions and any objections and motions to strike on or before August 30th, 2019. Defendants will file their replies and any evidentiary objections in support of their TCPA motions on or before September 3rd. Okay, where does it say anything about amending a petition? I mean, I'm looking for it. And I'm trying to figure out where. If you notice, so it says violation of the Rule 11 agreement. See Rule 11 agreement. Plaintiff will file his responses to the TCPA motions and any objections / motions to strike on or before August 30th. Emphasis added. An amended petition isn't a response to a motion. That's a response to a motion. They're two different things. Clearly different things. Lemoyne is going through what many people go through. It's called contract regret. It's when you sign a contract and then you find out that the terms aren't what you want them to be now that they have gone wrong for you. So when you have contract regret, you try and go back and make the terms say something different than what they say. So I guess that's his argument. He's going to say that that even though they filed a response and they filed a petition, or the amended petition, that the amended petition is somehow a response. But good luck. Further, this court has discretion under Texas Rule of Civil Procedure 70 to deny an amended pleading when it functions as a surprise to the opposing party. See Minor versus Oland. Here, the failure to... So they have to justify the surprise. Now, mind you, there is actually justification of the surprise. Or there is a test that the court goes through for surprise, but it's none of this. So here we go. The failure to comply with this court's order and Rule 11, which they didn't actually fail to comply with, while submitting the fraudulent affidavits, which they withdrew, and fraudulent is a loaded term. They use it as a defined term because they want to brand it like Trump, right? Crooked Hillary. That doesn't mean that Hillary is literally crooked. It's what Trump called her. And it was very effective, and that's why they do it. But there's nothing to suggest they were fraudulent. They were defective. Defective as to form. Only to try and backdoor them as attachments. Oh, Jay Sean, don't lie. You love the backdoor.
With the con sluts.
Only to try and backdoor them as attachments to the second amended petition functions as a surprise. Surprise! In particular, because defendant's strategy was built around timely filing responses based on the first amended petition, the second amended petition impacts defendant's evidentiary objection and reply strategy. Literally, these are killing my case, even though the claims in the first amended petition are the exact same. And here's the interesting thing. Lemoyne is again overplaying his hand. He's again overplaying his hand. Right? Because his job at TCPA is to prove two things. First, that the TCPA applies because the lawsuit impacts a protected right that is covered by the TCPA. That's part one. Then it's Ty's job to show a prima facie showing of the cause of action. That's Ty's job. And it's not actually Lemoyne's job to controvert the evidence Ty puts out. It's not. That's the big problem that Lemoyne's going to face, is that a prima facie showing is on this stuff. Here's what we've got. We can make these claims because we have specific factual allegations that lead to the conclusion or lead to the rational inference that the elements of the cause of action occurred. And then they have to go back to Lemoyne to figure out if he can prove any of his affirmative defenses by a preponderance of the evidence. So he can't actually controvert the prima facie case. He can only make his evidentiary showing for having better evidence than Ty on the affirmative defenses specifically. Specifically on the affirmative defenses. We know that truth is not an affirmative defense when it implicates a matter of public concern, and that's been their entire argument, is that this is a matter of public concern. If it is a matter of public concern, they don't get to assert truth as an affirmative defense because Ty bears the burden of showing falsity on the prima facie showing. So, what's their affirmative defense? They don't get to controvert truthfulness. And all of the affidavits or all of the declarations go to the heart of truthfulness of the matter, or more importantly, proving falsity. They go to proving falsity. So they don't get to do that. So their defenses are hyperbole, which they produce no evidence of hyperbole. None. Their defenses are the Section 230 thing, which might apply to retweets, but I don't think that's even a good argument. And their other one is libel proof, which they haven't produced any evidence that Vic is libel proof. And they're going to have a really hard time doing that. Plus, Vic has produced tons of evidence that he's not libel proof because he's still going to some conventions, even though he got uninvited from others. And the conventions he goes to are definitely successful. So he's not libel proof. He definitely took damage from their libel. And then finally, the last one is a qualified or a privilege, qualified privilege between the defendants to state these things. Which qualified privilege tends to mean their statements to like an investigator or the police or something like that would be protected, but their statements to the public on Twitter are not going to be protected. The Monica Rial calling up and threatening to cancel her contract to Christopher Slatosh, if he doesn't cancel his contract with Vic, that's not actually protected. That's not a qualified privilege. That's tortious interference. Textbook tortious interference. I will breach my contract. I will breach my legal obligation to you if you don't breach your legal obligation to someone else. Not I will cancel by the terms of the contract. Not I will not renew my contract. I will breach it. I will also induce others to breach it. That's TI. They don't have affirmative defenses for this. So again, Lemoyne's big problem here is that these things are not a surprise other than he's surprised at how bad it demolishes their case at the TCPA. And he desperately wants them out. Desperately.
Hyperbole. They're breaking our strategy. I don't know what to do.
Defendants request a hearing for sanctions against plaintiff and Mr. Beard after the court renders a decision on the TCPA motion to dismiss. Defendants will appear on September 6th for the motion to dismiss, and if successful, a subsequent hearing shall occur to determine the appropriate award of attorney's fees and sanctions against plaintiff. There also should be redress for the fraudulent affidavits, in which Mr. Beard and plaintiff are the key participants. Because of the timing of the fraudulent affidavits and the second amended petition and defendants' obligations to file a timely reply, that motion cannot be presented today.
But it is coming. Just like me.
Conclusion, we want relief and sanctions, or a hearing for sanctions. We want all this stuff stricken. We want to win the case. So there you go. Let's take a look at these exhibits real quick. Here's the declaration of J. Sean Lemoyne. Did you say there are times when you could break a contract? I mean, you break a contract, there just may be legal redress for it.
I am a partner at the law firm of Wick, Phillips, Gould, and Martin, LLP.
I'm of sound mind. Well, I mean, can we get him for lying under oath? Competent and authorized to make this declaration, the statements of which are within my personal knowledge, true and correct. We'll see if they're true and correct, Jay Sean. We'll see. I am an attorney at law, duly admitted to license to practice, and licensed to practice before the courts of the state of Texas. I was so licensed in November 2000. My practice is based out of the DFW Metroplex, which includes Dallas County, Tarrant County, and Collin County, Texas, and has been so for my entire career. I'm counsel of record for defendants Monica Rial and Ron Toye. On August 31st at 12:08 a.m., I sent an email. True and correct copy of the relevant insert is below. Prior to and up to 12:08 a.m., no one from plaintiff's counsel's office had emailed me to identify any issues they might be having with filing and any response or other filing. They don't have to, but 12:17 a.m., plaintiff's counsel forwarded me and others an email from so he left out at 12:10 a.m. Plaintiff counsel responded. Plaintiff's counsel responded to your email saying that they had technical difficulties. Again, why leave stuff out? Why leave stuff out? An email from efiletexas.gov indicating that plaintiff had initiated an upload at 12:15 a.m. that had failed. Below is a true and correct copy of the relevant portion of that email. On August 31st, plaintiff ultimately filed his response to defendant's TCPA motion to dismiss and objections to blah, 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 supplemental evidence. Now, he doesn't say at 12:27. He's very heavily weighting this declaration, right? On August 31st, I took a snapshot, which is true and correct image, of the relevant section of the Twitter account for plaintiff's counsel, Ty Beard, which is here. Everything filed. Now notice he doesn't include the time. Jay Sean, why don't you file it with the time? Why didn't he file it with the time? What's this tweet? Maybe I'll have to give Jay Sean a, let's see. Ty Beard. That's on August 30. Here we go. It's almost like, here we go. It's almost like you can actually figure out the specific time right there. Right in the whole tweet. If you just included that. So that's at 1:07 a.m. So that was significantly later than when they actually filed it. This would have been 40 minutes after. But he doesn't, for some reason, he just doesn't want to show what time things occurred. Because he wants to say on August 31st. He doesn't want to say at 12:27 a.m., 27 minutes into August 31st. I also took the following true and correct image snapshot. This is good. This is good. He figured out the time on this one. Let's check this out. True and correct image snapshot from Mr. Beard's Twitter account for the purpose of establishing that he was in Tyler, Texas on August 30th, which is important because Mr. Beard has submitted 3 affidavits that he purportedly notarized in front of the affiants, presumably while all 3 were in Tyler, Texas. So he's got the snapshot here. In order to determine what time this photograph was taken, I clicked on the photo, which took me to the Twitter handle for at UsaMad. Hey, what up, at Usa? And I took a true and correct image snapshot of the photo below, which indicates that this photo was taken at 12:55 p.m., which would put Mr. Beard in Tyler, Texas at the time. Now look at this. He cited the time it was tweeted as the time the photo was taken. Now it very well may have been. It very well may have been taken at 12:55 p.m. Maybe the person taking the photo at 12:55 p.m. Used the guy in the photo whose Twitter account it was to upload to Twitter for him. Maybe that's what occurred. But I'm pretty sure that's the time that the tweet was posted. So, you know, we just go ahead and say that apparently Jay Sean doesn't understand how time works or how technology works. The boomerist of boomers. Automata says, Lemoyne argues that the context around a tweet defines meaning so much that not including it is fatal. Spoiler, yet the same would apply to retweets. The context defines its meaning such that it's not just a republication. Yeah, also, he can argue that at trial. At TCPA, all of the inferences get to be drawn for the benefit of the plaintiff. Texan 83 says, hey, Nick, would the exclusion of the time that the tweet from Ty be considered without context? Asking for a mosquito-bitten friend who demands context of some 400 other tweets by an acquaintance biz. So, I also took the following true and correct image snapshot from Mr. Beard's account below. And so he says, late afternoon in the BHBH conference room today. Upon information and belief, the reference to BHBH above refers to the law firm of Beard, Harris, Bullock & Hughes, which maintains a website. Based on Mr. Beard's comment, it appears that he was in Tyler, Texas on August 30th, 2019. Yes, again, I think that's likely true, but based on this definitely accurate photo of the Beard, Harris, Bullock & Hughes courtroom, of which Ty Beard is clearly right here, yes. This is definitely a photo that was taken and of Ty and posted right there. So that's from their security camera. That's why it's a little grainy of an image. It's not because it was, you know, so again, he posted a picture. I believe 100% that Ty was at Beard, Harris, Bullock & Hughes that day, okay? But think about what this is. This isn't a picture of Ty at the courtroom. He could be suggesting that that's what was going on at the office without him. Like, if you really wanted to get technical on the argument, this guy is insane. This guy is insane. Okay, anyway.
Based on Mr. Beard's comment, it appears he was in Tyler, Texas on August 30th.
Upon review of the affidavits attached to response, I noticed that Mr. Beard was the notary for the affidavits of Chris Slatosh, Chuck Huber, and plaintiff true and correct copies of the affidavits. Following tables based off information from the affidavits, information I had obtained from Texas, and MapQuest.com, which I used to look up information on the affiants so I could calculate distances between Mr. Beard's office and the affiants' assumed or known residence. Just so you know, Jay Sean Lemoyne, you have just fully 100% without question, you have officially endorsed the doxing by Kiwi Farms. Welcome to the party. Welcome to the party, Jay Sean Lemoyne. That method right there. But look at how old he is. He uses MapQuest still. But which is different than what he says in his petition. In the petition, he says he used Google Maps. So he's clearly a liar. But here we go. He's officially endorsed the exact method that Kiwi Farms would use for doxing someone. You go to official records, you find their address that is publicly available, and you post it. That's it. He did it. He doxed them as hard as Kiwi Farms does. Jay Sean Lemoyne is inviting goodness gracious. I guess we have to report him to Twitter and everything. I'm kidding. I'm joking. Don't report him anywhere. But he's doxed and called for the harassment of Slatosh, Chuck Huber, and Vic Mignogna by doxing them. Okay, anyway, we saw these earlier, so I'm going to not keep their thing up on screen anymore. Affidavits are unequivocal that they were signed in front of Mr. Beard. Below are true and correct images, snapshots of the jurat. Given that none of the affiants live in Tyler, Texas, and considering August 30th, 2019 was a Friday before Labor Day weekend, I began to suspect that none of the affidavits were signed in Mr. Beard's presence. It would be highly unusual for individuals to drive to Tyler, Texas, or Mr. Beard to drive or fly to them, when any licensed attorney knows that an affidavit can be notarized by any authorized notary wherever they are. Let's see. Mr. Beard's tweets that he was in Tyler, Texas on August 30th lent credence to my belief that the jurats on the affidavits were in fact false. I next decided to determine if social media placed one of the three affidavits somewhere other than Tyler, Texas. I'm sure he thought of all this, by the way, and wasn't just watching Twitter. I know it. I know it. By looking at the Instagram page for Kamehameha, which is found here, I clicked on the picture below, which is true and correct image, true and correct hyperlink. Mr. Slatosh's affidavit indicates that he is the owner of Kamehameha. This indicated to me that Mr. Slatosh was at the Henry B. Gonzalez Convention Center on August 30th, which is located in San Antonio, Texas, as evidenced by the following. Below is a true and correct image snapshot from his website confirming the location of Henry B. Gonzalez Convention Center. Mr. Slatosh was in San Antonio, Texas, and Mr. Beard was in Tyler, Texas, absent extraordinary travel, which makes no logical sense given the presence of notaries in most banks and law firms in both cities. Mr. Slatosh deliberately signed an affidavit outside of the presence and not even in the same city as Mr. Beard. I suspect, given the distance between Fort Worth and Tyler, Texas, that neither plaintiff nor Mr. Huber were in the same city when they executed their respective affidavits. On August 31st, Jamie Markey's counsel, Sam Johnson, sent a letter to Mr. Beard demanding his notary book. True and correct copy of that letter is here. In order to give Mr. Beard an opportunity to explain himself, I sent an email in the morning. A true and correct copy is attached here. Rather than explain the mystery of how Mr. Beard notarized three affidavits in Tyler, Texas for three witnesses that each live over 100 miles away, he filed a second amended petition. Second amended petition appears to be a mirror image. We've read all this. Same whining before. Finally responded that fraudulent affidavits were mistakenly submitted with defects in form and threatened sanctions if his fraud on the court were disclosed. Plaintiff's counsel has withdrawn the fraudulent affidavits, essentially admitting to his misconduct. Beard and Bullock have been sanctioned before. He shouldn't have included this, in my opinion. He shouldn't have included a lot of this, but... here we go. Here we go. Was Barbara Morgan in Dallas County on September? Just kidding. Just kidding. So, so here's this stuff. I want to get down to the email exchange because he only included the partial email exchange before. Let's read through Ty's emails. Exhibit 3. Exhibit 4. Here's Ty's email. Let's read the whole thing because he left out most of it. Okay. Brian Dewey says, check the metadata tags of the image to see if it contains its creation date. No. I don't know how to do that. Tucker says, that late afternoon BHBH conference room meme is pure gold. Props to Ty for having impeccable Twitter skills. They grow up so fast. Wipes tear. Big Red Bear. I gotta read yours right away. I stand with the People's Republic of China. Screw Hong Kong. I've always appreciated the iron boot of a Han Chinese ethno-state ruling over all other groups in China. Thank you, my friend. Very funny. So Ty says, there's been no fraud. The affidavits were mistakenly submitted with defects in form. This is my notice that we're withdrawing them. I'll serve notice tomorrow, but this email is sufficient notification. No harm has been done to your clients, and the declarations in our second amended petition are identical to the defective affidavits with one very minor exception. Otherwise, declarations have the exact same statements as the affidavits. And we are allowed to amend our petition before the hearing. Indeed, the case law seems to almost demand it. So there is no legitimate basis for you to file your motions to strike them. Your remedy is to object to the affidavits as being defective in form. Anderson's objection to the county's summary judgment evidence include authentication, verification, not under oath, not an affidavit, statement unsigned. These are all objections to form. See Tri-Steel Structures. See, here's the ultimate thing. The remedy for a defective notary, or I guess standing to complain about a defective notary, is actually on the signer of the document. That's the person who gets to come in and say, I didn't sign that, or that's not a true and accurate copy of what I've signed. They're the ones with the remedy. You're going to object to the evidence here, the affidavits as evidence. You get to object to them as, which includes the authentication and verification, or that it's not an affidavit, or that the statement is unsigned. You get to object to the form of it. The remedy for a form objection is to correct the objectionable material. So Law Twitter's blowing up about this being fraud, this sinking the case, all of that stuff. Here's the reality. I mean, Judge Chupp may very well determine that. Sure. Here's a Texas Court of Appeals from Fort Worth where petition was denied. The Supreme Court just said, no, this is fine. And they say these are form objections. So they're going to they would have to convince Judge Chupp that it's not a form objection and that the activity was so egregious. Now, they don't have any evidence of this. Lemoyne is puffing a lot. They don't have any evidence that there was some sort of malicious act or intentional act to defraud the court. They've got nothing about that. What they've got are potentially some defective notarizations. Let's come up with a hypothetical. How do you get a defective notarization outside of a fraud, right? I want to defraud the court is one way, right? I'm going to notarize this even though I know that notary is improper. Another way is maybe you just don't understand notaries. Maybe you made a mistake in how notarization works, or that personal appearance means literal personal appearance. And by the way, again, despite what Law Twitter says, lots and lots of notaries and lawyers don't understand that personal appearance literally means personal appearance. So it's entirely possible that a notary could, for any other reason, determine that they are sure that that is the signature of the person. Lots of notaries have done this where they sign and notarize something that was not signed in their personal presence. Maybe it was signed down a hallway. Maybe it was signed while they were in the bathroom. A lot of stuff happens like this all the time. I'm not saying it's right. And no, I have never notarized a document where someone was not directly in my presence or anything like that. But a lot of notaries do this and don't understand that personal presence means personal presence. In fact, there's case law on it for the very reason that lots of people don't understand that their personal presence means personal presence. So if they were not personally present when Ty notarized them, if that's the case, again, I don't know. I wasn't in Texas, but that's what's being alleged. Fraud is not the only way that happens. It could be a mistake. And if it's a mistake, then it's not a fraud on the court. It's not a fraud on anybody. The people with remedy would be the people who signed it. And the remedy for Jay Sean would be to object to the form of the affidavit, which, since they withdrew them, there isn't anything to object to. So there you go. And that would be, I'm guessing, if this somehow comes up at trial and that's the actual situation that occurred, then that would be the argument. And the ultimate question is going to be, how are you harmed? How are you harmed? Because remember, what they're asking for as a remedy is that the plaintiff loses the case. That's why they're so desperate to assign guilt to the plaintiff and the witnesses. They want to make this into a criminal scheme. Again, a bold strategy. But they want to make it into a criminal scheme because they're asking the court to dismiss everything and grant them a victory at TCPA. That's what they want to happen. They want to have happen. And that's why they're overplaying their hand, but I think that's going to work to their disadvantage. Freighter J, it actually needs to be in person. A video of the person signing it shown to the notary does not suffice. Nothing suffices outside of their literal personal presence, which is, it's kind of counterintuitive, right? Like if your mom is on a Facebook chat with you and you're a notary, and yes, you can notarize your mom's signature. Your mom is on a Facebook chat with you and you watch her sign a document and send it to you, and then you notarize that it was signed. You can prove it. You guarantee it. Everything's perfect. No. Still has to be personal presence. And I'm telling you, a lot of people don't know that. And that's not fraud. That's not malice. That's just people not knowing the rules of being a notary. So, and again, I was a notary. I'm very good with rules. Part of why I became a lawyer was because while I was in banking, I'm very familiar with how rules work. And I like the rule and regulation aspects of it because I remember them very well. But a lot of my colleagues did not. Okay? Let me just suggest that. A lot of my colleagues did not understand that you can't notarize something unless they're there signing it in front of you at the time. So there you go. The Texan 83 says remote notary is a thing in Texas. I don't actually think, I mean, maybe that is, but the rules I was reading didn't show remote notary. It showed that you could remotely you could notarize an electronically signed signature, but you'd still have to have them personally present. But anyway, here we go. Of course, there's no need to do this since we've told you that we're withdrawing them. Here's the sanctions fight. And then he left out this part. Let's get this. Let's go to this part. There are also rumors that Mr. Toye has been contacting witnesses and trying to induce them to alter testimony and threatening them with retaliation if they don't. While I have not credited those rumors up to this point, I will of course look very closely into them if we get into a sanctions war. Given his tendency to use text messages and direct messages, it should be easy to substantiate these rumors if true. And if that's not a shot off the bow, or a shot across the bow. And now that you have noticed that we're withdrawing the defective affidavits, we will of course argue that filing motions to strike will violate rules 13 and or 10 if filed. So I actually am not... I'm not aware of what he's referencing in this. I haven't heard those rumors personally. I don't think. But they are very, very interesting to me. Chelsea Ditmore says, hey, Nick, been listening to you for a long time via Mr. Tony Tupin. My better half. I have a patent question. Would love a quick tip from you. Keep on crushing it. Chelsea, email me, please. Email me, and either I will answer that question or I will get you to a patent expert. One of those two. But yeah, and tell Tony I say what's up, man. I miss him. I miss him very much. Okay. So then he says, Mr. Beard, it is now apparent that did in fact attempt to commit a fraud on the court. In addition to filing a cross motion to strike your response and objections to evidence, please allow this to serve as our attempt to confer to strike your newly amended petition. It is unfortunate that you have caused Mr. Slatosh and Mr. Huber to engage in this type of behavior. And he says, Mr. Beard, I am gravely concerned that the affidavits of Vic Mignogna, Chris Slatosh, and Chuck Huber were not signed in your presence, despite the representation your jurate. Oh, okay. So I guess Ty didn't respond to, or no, this is his response to this part. Okay. He's got them in there backwards. Hate when they do that. So. All right. So I believe you guys on the Texas remote notary thing. I haven't seen it. I wasn't looking into remote notary. So I haven't seen that at all. But I believe you. I believe you. But I don't think that's an issue here. So let's see. Okay. So that's the big stuff today. I mean, of course, there's the defendant's omnibus objections to plaintiff's TCPA evidence. So they have their motion to strike. That's what this is. And they have sustained and denied objections to all of this stuff. They have it all listed out here. I'm not going to go through this tonight because it will take too much time. Maybe we'll go through it tomorrow, depending on what happens, unless there's something else. I don't know. And of course, defendants Monica Real and Ronald Toya's response to plaintiff's objections to and motion to strike evidence offered. So their response to the thing that they're objecting to in general, and then reply in support of their motion to dismiss. So this is just another. So, I mean, look at this. He filed so many pages today. And then they've got a, let's see. Oh, yeah. So I'm not going to go through this tonight because I'm getting tired of reading Jay Sean's arguments. They hurt me. They hurt me in the brain. I may have missed some $20 chats. I'll go look for it. Go look for it. I have mail. And why do I have mail? Okay. All right. Let's see. What do we got? Okay, I've got that. What else do I have? What is this? Okay. I got to stop looking at this. Yeah, we're going to be done for the night on the reading stuff. You know, here's an interesting thing about those filings. Because you guys can only look at me going like this. Some old boomer. Looking at stuff for so long. Here's one of the interesting things. Arguably, Lemoyne is trying to intimidate Chuck Huber and Chris Slatosh, right? With this filing. In suggesting that they participated in a criminal scheme. He doesn't want them to participate in any of this. I think his filing, I mean, again, you guys can draw your own conclusions. Absolutely. But I would suggest that he overplayed his hand. And here's the silly thing that they all did. They could have just brought this straight to the hearing. They could have brought it straight to the hearing. And at the hearing said they were defective. Not sure why they didn't do that. because, you know, they could have gone ahead and just dropped it at the hearing. That would have been much better strategy. But it's almost like they got some balding idiot on Twitter to tweet about this stuff constantly throughout the day. And then they had to address it. I would have just, I would have maybe raised it at the hearing. Or right before the hearing. Or literally any other time than when they did. Okay. All right. Let's wrap up the we're going to go through the super chats here. We're going to go through the super chats. If you do peace out before the super chats are all read, thanks for joining the stream tonight. Stream tomorrow will be highly determinated. It will be determined by what happens tomorrow. This stuff is moving so fast. I'm not sure if I will have a stream on Thursday. And I'm not sure if I'm going to have a stream on Friday, which I know you guys don't want to hear. I know you don't want to hear that I'm not sure if I'm going to have a stream on Friday night. I will find out when I can stream in regards to Friday, Saturday, Sunday as soon as possible. But I am at a 3-day event. Friday night, Saturday night, and Sunday. Well, I guess Sunday is not an event day. Sunday is not an event day. Friday night and Saturday night are. There may be a daytime stream on Saturday. There may be a late night stream on Friday, but I have a feeling I will be trashed. So I don't know. But I am desperately working to figure out when I can stream. Okay? Because I know you guys want information about what happened on Friday's hearing. And should I appear at that hearing or not, I will probably have information about it, right? I want to bring you a show as soon as possible after that hearing, but I don't know exactly when that will be. Stay tuned on Friday. There may be some midday short cell phone streams from wherever I might be on Friday. I'm gonna tell you, I have an art event on Friday and Saturday that I look forward to every year with Lady Rackets. We get to dress nice and rub elbows with people who are much more decent than I am, and that's fun. So that's what we'll be doing. As far as the hearing, I might get updates in the middle of the day. If I do, I might do just some short cell phone streams to update you. Check your DMs. Oh my gosh. We're on Twitter. What do we got? Do I need to check them now? Who, check my DMs. Lizzie Marie, what's your Twitter pass? What's your Twitter pass? Or Twitter name. Okay. Anyway, I'll have to see. Okay. Lizzie Marie, what's your Twitter handle? What's your Twitter handle? While I wait, I'll go ahead and let's see. Mario Carter 13 says, just according to Kaikaku, Kaikaku means conslut. Okay, thank you. Andrew War Snowboard says, Nick got stung by a white Anglo-Saxon Protestant. He is the Fuhrer now. F in chat. That's true. D says, you've probably already talked about this extensively tonight. However, why is Ty taking such unnecessary risks this late in the game? Disappointed. Blue Tanks 21. Let me see. Let's see. What is it? What is it? What is it? BLUU. Oh my goodness. All right, let me check the messages. Talks about a coworker saying he would ruin her life and talks about defamation, but the whole video is very important. Oh, Stephanie Nadolny's side of what happened. Okay, I'm not doing that stream right now, but thank you. I don't like popping up random videos in the middle of a show. I got to review them first. But thank you for that. Sorry. D says you probably... Yeah. I don't think he's taking unnecessary risks. I think that it kind of looks like he just made a mistake. So, because the reality is you don't need an affidavit. You could use an unsworn declaration. You don't need an affidavit. So I don't think that any defects in the affidavits were due to some risky maneuver that they were trying. It just doesn't make sense. Let's see. As Cybertest says, Jay Sean shook with anticipation as he slid his semi-rigid member into the mosquito box. Don't pause me again, baby. He wheezed as the barbed proboscis slid into his semi-stiffy. I've missed your caress, he whimpered. That is horrifying. Ew. Ew. Okay, I will pull up the GoFundMe. Because, let's do that. All right, we did break 242,000, 242,176. So there you go. Again, I'm not shilling the GoFundMe too hard right now, mainly because I want to see how TCPA goes. I don't want people to like dump a bunch of money. If the very real possibility that this thing gets kicked out at TCPA occurs, I want people to know what's going on. But I mean, if he does lose at TCPA, there is appeals and stuff like that. And so I'll certainly talk about it, but I want people to know what they're giving money to. And at this point, I can't do that until we see some resolution on the case, but on this TCPA. So that's why I haven't been like crazy shilling the TCPA. It's out there. But I just want to let you guys know that I plan on whatever happens, I plan on going ahead and filling you in and then talking about the GoFundMe more. So I just, like I said, I'm bad at selling things. I'm bad at shilling things. And I don't plan to actively shill the GoFundMe while we're coming up to this point of limbo. And I don't like doing that because I wouldn't want that done to me. So there you go. So, anyway. Okay, Harbinger 345 says, I cannot tell a lie. This thumbnail is a masterpiece that belongs in the Boomer Museum of Photoshop. No one important says, this damage control on Twitter makes them look like true clowns. They've hit rock bottom. Nice strats, Ty, Nick, and of course everyone else here. Angel Rin 89 says, late and my son's a FAG. Ryan Stewart says, late and gay. Angel Rin 89 says, Nick, have you seen the old Glassdoor reviews highlighted on the farms today? I have. I've seen a lot of them. But I think some of them do say, it's a great place to work because you just sleep your way to the top or whatever. Unicorn. And for the record, I have heard directly from Funimation employees that there are certain people who are female who literally the prevailing thought is that they did sleep their way into their position. I have heard that. I can't verify it, so I'm not going to name names, not going to do anything like that. But this casting couch thing is not a secret at Funimation. Okay. Did I say shilling the TCPA? Dang it! Shilling the GoFundMe. Okay, here we go. Sorry. Unicorn Meat Man says, hey, I really want to start a vid explaining everything that has happened with Vic so far. I was wondering if you or someone else posted documents about the case anywhere for my research. Well, Shane Holmberg has a Dropbox that has most of the documents, if not all of them. They're also available on Kiwi Farms. I don't post all the documents, although they are all available in my Discord, which you could join, but I'm not going to tell you that you have to get them. Otherwise, you can get them on Research Texas Courts, and you can pay for them there. But there's, there are places to get them, so you can start your research. Mike Lombardo says, Flash, please check DMs. Fluffy Side Up says, Lemoyne sent that wasp from Texas full of his spite. As long as it's not full of his disease. Blink Your Eyes 1400 says, if it makes you feel any better, I got stung by a bee while sleeping in my bed at night in my home. It was in my hand too. Kalinka Pavlova says, you just wanted to explain the redness on your palms. I'm just kidding. That's a joke. Kalinka Pavlova says, death to all wasps. Bees I can forgive. Pyretta Riddle says, at Ty Beard, I asked my sister to deliver a bottle of Jack to you since she is basically your neighbor. Hopefully you get it soon. Basement Troll Production says, Nick, have you seen Josh Martin's meltdown on Twitter the past few days? I try and avoid that guy. He seems really stupid. Surprised that Funimation isn't reeling him in. He's also tagged you and Ty periodically. Seems to have gone under Kiwi Farms' radar too. Well, I mean, I don't care if Josh Martin tags me on Facebook or on Twitter. He's pointless. Hi, I'm Boo. Okay, you did it. You did it. Good job. HB says, thanks for fighting the good fight and keeping us up to date. Sent you a couple of jars of homemade orange marmalade to your P.O. box. Enjoy. Ooh, thank you. Thank you. I read a riddle says, gotta go to bed early, day tomorrow. Love you all, and Con Sluts and Frick Chambers. Cara Paupus says, casting couch seems way too good to be true. We'll see. We'll see. Or we won't. I don't know. Maybe it is too good to be true. Humble Marty says, did they sleep their way to the top or lick their way? Oh, wow. Joni Baloney says, will you get any cool lifelong disease like Lemoyne did after getting stung by the wasp? Rectum warts, aka Shane Holmberg's, maybe. Mark Nicholas says, just saying hello to Ron's transcriber. Very polite of you. Poor transcriber. Always gets forgotten. Kalinka says, I mean, yeah, you got stung by a wasp twice today, but Veronica, Jamie, etc. really kicked the hornet's nest when they kicked Vic. Enter the QB says, in Lemoyne's voice, you have my respect, Nick. When I'm done, half the consulates will remain. I hope they remember you. Gong Shubin said, could Sabat et al. Sue people for defamation who speak out about his casting couch shenanigans? Oh, wait, we read that one earlier. We read that one. I hop in a one says, Andrew Yang for President 2020. Check out his stream with Ben Shapiro. Patrick H says, when are you going to have Josh from Kiwi Farms on to talk about the Mountain Chosen Supreme Court filing? God, I wanted to do it this week. I got to talk to him. Maddox 1000 says, I showed up late but still caught the stream. Can you summarize what's going on here? Not at this point. Fatal System Error says, buying my house this month. Hey, congrats. If you're ever passing through Gem City on your way to Texas or whatever, hit me up, drinks on me. Reborn Exists says, hey, Nick, it seems like Jamie is freaking out. Oh, wait, I read that one. Kalinka says, so the rumor of Sabat being banned from a con. Is that a rumor? Or did I hear that from the con? Peace in Valhalla says, play some DBZ audio for a friend at Katrina, please. No, I'm not going to do that on this stream right now. Krusty Orangutan Tit says, Sabat can't get enough of Funimation VAs gathering his Dragon Balls and make them wish for the sacred ointment in Minecraft. Kidda says, check the farms. Apparently the Glassdoor review specifically mentioned quid pro quo a lot. God, oh, jeez. Liam Gray says, Xenotype, the new face of ultra-violence. Riniflex01 says, casting couch victim number 2, Meredith McCoy, voice of Android 18, question. Voiced 18 in DBZ. Dragon Ball GT was not invited back for DB Kai in 2007, and now is back for Battle of Gods, Resurrection F, and Super. I don't know. I can't tell you. Can't tell you till I can verify it. GRP poll says, how much do you think Sony is regretting buying Funimation the more information comes out? Apologies for Super Chat absence. Gaming takes time. Never apologize for not sending Super Chats, man. Never, please. Whiskey Gamer 83 says, first time Super Chat. Hey, thanks, buddy. Been watching since early January. Keep up the awesome work. In Lemoyne voice say,
draw me like one of your con sluts, Nikki.
ISWV. Eric Collier says, Ragnarok or a four-way with Monica, Jamie, and Renfamous? Ragnarok. Asia Fraser says, Lemon's lot like a mosquito. If you don't slap him, he won't stop sucking. Ron is like a vacuum cleaner. He sucks, he blows, he gets laid in the closet. Harbinger 345 says, is Lemoine trying to impress the judge or the Twitter mob of weirdos and lawyers who cheer for him? Just a thought. I think that second one a little more, but he might be going a bit too far. Might be going a bit too far. Gong Shubin says, if I had $1 for every time Ty lost the case, I'd be able to pay Vic's legal fees myself. Evan Rogers says, is it normal to want to castrate Lemoyne with a Rambo knife after reading this? No. And that is discouraged activity. That is discouraged activity. Gong Shubin says, breaking the bill that has plunged Hong Kong into protests and chaos for months on end is set to finally officially be withdrawn. A decisive victory for freedom on Chinese soil. Pour one out for your fans over here, buddy. I will do that. I will do that. If I had a Chinese whiskey, I would do it with that, but I don't. We're going to go with a Glenlivet and a Dura. To Hong Kong, to freedom, and to the people who fight to uphold it. We often forget that freedom requires blood and sacrifice in the face of tyranny. It's unfortunate that that's true, but it has been a truth for as long as anybody knew what freedom was. So, to freedom. Okay. And from David Park says, did Toye technically commit perjury / lying by omission during his deposition when Ty asked him about his divorce? Was he obliged? Say there were 2 divorces. No. Watching it in hindsight, he was incredibly nervous right then. I think he was nervous because Ty was about to ask him if he beat his wife. Or if he threatened her, or if he threatened a judge. I think he was very, very afraid of it. Okay. Let's see. Asia Fraser says, next time you see Vic, ask him if it is ever okay to be a cuck. As a Chad, what's his advice on how can a cuck be baptized out of his ways of cuckoldry and into Chadism? Well, you start drinking cow milk. Oh, man. And you just, it's never okay. It's never okay to be a cuck. That's not kink shaming. That's just truth. Mark Nicholas says, Lemoine's response seems to reek of butthurt. It sure does. Sure does. Bad Vibe says, West Nile equal brain damage. Lemoyne has it. Enough said. Oh, I missed this one. Sorry, West Nile Chan. Nick, Ty's 4D chess is no match for Lemoine's multi-boxing ace attorney and oxygen not included. You've lost the case again. Asia Fraser says, anyone else miss Casey? Lemon's blubbering melts brains. I do. I miss Casey very much. Gosh, I wish it was just me making fun of Casey. Indie Visualist says, Lemon is why the Bard said kill all the lawyers. DCV Titan says, with all these overly verbose and mentally deficient filings, at least we know Führer J-Dolph has a future in writing crappy fan fiction or shit fix. Damn the hoops to get around censorship. Yeah, just ask Hong Kong. Just kidding. Armchair Warlord says, starting law school in 2 weeks. Love the show. Hey, congrats, buddy. Good luck. Don't get discouraged. That first semester sucks. Second semester sucks worse. And then it's great. Mr. Obi-Wan 2020 says it can't be pending against the Supreme Court of Texas because Ty hasn't seen a courtroom prior to you. That's true. Individualist says, yes, all the corruption is why Hillary is crooked. Crazed Corgi says, Rekieta Law, where can I buy Milo's sweet tea? I get it at Walmart. They have it at Walmart. They have it at some Targets as well. Gladiator says, Supergirl got cucked by Senpai with Karen. Bad Dragonite says, last night, Rekieta Law yawn-splaining the interwebs. Oh, man, I was so tired last night. Whew. Now I'm yawning again. Dang it. Rick1186 says, could Moronica's lawyer be sanctioned for these filings? Probably not. In theory, it's possible, but unlikely. And I don't think Ty would ask for it. Unless Lemoyne pursues the sanctions hard. If he does, I think that'll happen. I think, Ty would go after him. NSR 9mm says, effective July 18th, HB 1217, remote notary. So there you go. Siren Jag says, dial me in. I'll read a paragraph with my one voice I do. I bought a Ridge wallet for my dad for Christmas. Huzzah! Hey, thanks, man. Good job. Hope he enjoys it. Lord Blackwind says, if no show on Friday, drink a bottle of Jack Daniels. Oh, God. Tom says, just kidding, guys. I'm streaming on Thursday and Friday. Dang it! You got me. Lane 20 says, as Tyrion, I drink and I know things. Freighter J says, I think I figured out Ty's mistake. I DM'd you. Okay. Lane 20 says, as reporter, this is Nick Rekieta updating you from the courthouse bathroom. Oh, crap. There's a woman in here. Did I go into the wrong bathroom? Kidda says, Gelburu, an anime image archive, is suing Google for blatantly refusing to respond to DMCA counter notifications. Safe harbor violation? Oh, I don't know. That's a good question. That's a good question. Blink Your Eyes 1400 says, no, Nick, that's what the sacred ointment is for. Kalinka says, Twitch? Yes. Yes, Twitch tonight. Also, free Hong Kong. Boom. Horatius 763 says, did you follow Vox's case against Indiegogo? He won. I did. And has he made an official announcement about that? I was going to talk about it, but I wasn't sure if he made an official announcement. I do intend to maybe have Vox on to kind of talk about these things. I don't think he can talk about the actual case. But I got to check it out. I got to check it out because that case is very interesting. Very interesting for this deplatforming stuff. Ayla123 Hamora says, okay, side question. You're a con goer now. Oh, no. Oh, no. If you could cosplay as anyone, what would it be? Yes. I wouldn't, but I guess Spike Spiegel. Sharon Young says, please pray for those in the path of Dorian. We may be evacuating in the morning. Go away, stupid hurricane, and leave South Carolina alone. Yeah, man. Good luck with that. If you have to evacuate, Godspeed. And hopefully, Dorian kind of calms down quite a bit. Conspiratorial Walnut says, bed with Monica. Get that blubber acting like flubber. Oh. Pooh Zerker says, Sabat walks Schemmel with fingers like Zoe Quinn. Big Red Bear says, is tyranny really so bad? Think of how much better off Funimation would be if it was owned by the PRC. We'd never hear from any of these people again. Eric Stein says, here's a 5 for all the nights I got to listen to you on the road in when I can't stay anything because I'm driving. Oh, thanks, buddy. I appreciate that. Thanks for listening on the road. Devil Under Nero says, hey, Nick, is the reason that Funimation keeps losing money not just from all the things they do to the fans, but from all the sacred oil they buy for Sabat's casting couch with Ron cleaning up after? Oh. Dollar Link says, Mr. Toye, have you ever threatened a court official? I do not recall. All right, now let's get in the ones from today. On the Justice Chat side, there's only a couple. We're almost done. Funk says, hey, Nick, have you considered a stream on space law? I have, actually. I don't know anything about it. But I think I know someone who knows a space lawyer. legal rights to colonizing and mining celestial bodies. Also, importantly, the property rights to the orbital paths of satellites is a big part of space law. I know a couple YouTubers who might be interested in a collab with you if you did. I'm very interested in doing it. I just don't know anything about it. Super Cuckarot says, rest in peace, Nikki Rackets. He got stung by the armored wasp and lost all of the cases. In lieu of gifts, please pour out a glass of your finest whiskey. Thoughts and prayers will be accepted only on his Discord or new project too. Kay says, Nick, could you please hug your camera and say, there, it's going to be okay. It's going to be okay. Carapapa says, honestly, Chuck's affidavit worries me. Such a bold claim that he can't personally confirm, coming from someone who has already demonstrated questionable judgment, might sink a good case with his own naivete. I don't think there's anything in Chuck's affidavit that would sink the case. They could say that the stuff about Sabat is irrelevant, but what they're, and they have said that, but what they're overlooking is that Sabat is tied to Funimation. Chuck ties Sabat to Funimation, says that he is a de facto manager at Funimation, that people regard him as having authority at Funimation, and Sabat makes casting decisions at Funimation, which makes him a vice principal under Texas law, and that could be very, very bad for Funimation. So I will play the outro today. Dave Youngson says, if Ty wins all the TCPAs, he's entitled to legal fees. Can the parties... He's not entitled to legal fees. If Ty wins all the TCPAs, he could get legal fees. I think his best argument, of course, is against Monica and Ron because of just how bad Slaytosh's declaration ruins them. I mean, it flat out makes the case, and they knew they did that. Filing a TCPA could seriously be frivolous, and all of the extra filings that they included, which have nothing to do with their affirmative defenses, that could be considered frivolous. So we'll see, though. Can the parties then be sanctioned on top for not paying them? Probably not sanctioned. They would just have to pursue it as a debt collection action. Is it the law firm that pays them, then client repays them, or is the client due to pay them straight away? It depends on what the court orders. Courts typically sanction clients. They typically only sanction lawyers if the lawyers do something so egregious that they think the lawyer themselves merits the sanction. Felipe Mouve says, Nick, thank God we have this a-hole Lemoyne at the other side because Ty's work here hasn't been stellar, to put it mildly. Yeah, again, being openly critical of Ty's work, specifically on this filing, Ty's been great up until this filing. This filing has not been good. One thing I haven't really talked about, Chupp is a trial litigator, a plaintiff's litigator. He's gonna know how this goes for plaintiffs, probably. In addition to being a judge, he's going to have dealt with defendant attorneys like Lemoyne. So that's one thing. The other thing, of course, is that while Ty's work on this motion has been less than good, less than stellar, on this filing, those affidavits, of course, apparently being the biggest mistake, that shouldn't actually prejudice the case. And if it does prejudice the case, you go straight to the appeals court and say, Your Honor, or you say to the appeals court, look, if I need to be punished as counsel for something, fine, but prejudicing the client for the counsel's actions that the client would have nothing to do with would be another step. And that's improper. And I mean, there's all sorts of stuff about just how hard it is to strike pleadings and all of that stuff. I'm not going to get into it, but that's out there. It's, yeah. His work up until this point has been great. He's been a great help to Vic. All of the filings up until the recent one have been good. Looks like they had a bad day. And that happens. It's going to happen in litigation. And actually, shockingly, back at the beginning, Ty mentioned, you're going to get wins and you're going to get losses as you go. But typically one error doesn't tend to sink a case because judges know. Bad Dragonite says, forget the filing. Possibly the real sloppiest work was done on Sabat's couch, possibly with Lemoyne and or con sluts. And then we got a couple more super chats that came in. Let me start playing the outro. Here we go. Hold on. So you guys know to stop sending them. Even though, of course, I love the super chats. But at some point, we got to cut them off. So here we go. Asphyxiation says, congrats on 75K, mate. May the tracksuit pants god smile upon you. Also got you a shout out from Jim on his last stream. He really enjoyed the leaks. Also, Monday Matt looks like a fat Ron Toy. He does. Sorry. Well, I'm glad Jim enjoyed that. Really. The one says, outer space is not real. Stop lying. Well, but it's fun to pretend that the dome doesn't exist. Kalinka Pavlova says, someone called Gur in the chat, sent you an email. I'll check it out. Rich Meister 84 says, which is more respectable, con sluts or cosplay thoughts? I think cosplay thoughts are more respectable. That's what Dominique Sky prefers to be called, from what I heard. FKA Frankenslada says, whatcha, I missed the early stream. Anything happen? Also, Fat Jarbo and I do not recall Man Fuse. Would it be Ron or a slob monster like Monica? Why not both? Why do we, just because of DBZ, we think fusion? Well, I guess fusion necessarily implies one, but what if their essence is too great to be captured in one being? What if they fuse and then through mitosis split into two new horrors? The one says it's time for Chris Sabat to take a sabbatical. And Satanic Potato says the solution to this is simple. We'll build a potato and make Kick Vic pay for it. All right, there you go, guys. There you go, guys. And the 75K stream is coming. I just need to put together something special for you. I want to do that. I don't want to just do it like while reading a document alone. I want to get a good guest on here or something to help out while I struggle through eating that pepper. But that is coming. I'll announce it as soon as I figure out the logistics, and we'll deal with that then. All right, guys. I will be on Twitch. You can come on Twitch, hang out, ask more questions. You don't have to donate on Twitch because there's less people, and I try and answer them. Probably going to play Risk of Rain again because I'm addicted. And Path of Exile update is in 2 days. So we'll do some Path of Exile when I get back, starting next week. And then someone can tell me how bad I am at that game, and I believe it. I believe it. All right, guys. Thanks for hanging out tonight. I'll talk to you soon. Peace. Peace.
Tonight, from the wide shores of Nairn to the hills of Glenlivet, there's no one who explains the